If your lordship kindly allows me to mention that that IJMA, Indian Jute Mills Association, whether the Jute Commissioner was to implement the central government notification for packaging of sugar in
Jute
jute bags.
bags.
They have given the report that it is default. Now, lordship has given us time to give exception. We will not give any exception. And the difficult part is that the Jute Commissioner is saying we will not implement, the matter is pending. And I will just ask for only for implementation of the of all the of all the gaps. Otherwise, well, the jute packing season, well, the sugar packing season is going on now.
Where is the matter?
The matter is number 57 in the list, my lord. 57 in the list. Well, this was my lord's last order. We will not give any exception to the report because report is in our favor. Number 57.
It's under the heading urgent motion. Under the
considers
heading urgent motion. It will be taken up on Friday. Friday's urgent motions are taken up.
Friday.
Wednesday.
Friday, I for personal reasons, I will not be there, lordship, this coming Friday, purely personal reasons. But then it is not really one industry. This is really the entire jute industry is getting impacted. Their mills are lying half.
You can join online also. There is no difficulty. Not possible.
Some personal difficulty.
Let us see.
If
Please
it can be, then next week, if it's possible.
Let's see if this Friday we can, if it can be taken up, then we can at least prepone the matter.
Very well, madam.
Please wait.
Grateful to madam.
Yes.
May I have a lordship's kind leave to mention an extremely urgent motion. My lord, the designated authority under the Food Safety and Standards Act, my lord, has issued a prohibitory order on the manufacture and sale of top biscuits manufactured by my client, by the petitioner, that is such food products under the trade name of Bees Farm. The order has been passed only on 10th of January. The authorities are insisting that the biscuits which are already in the market should be taken off the shelves.
Yes, if it is contrary to the law, then
no,
what?
Absolutely beyond jurisdiction order. Not at all contrary to law. These biscuits are sold for last 15 years. And there are other manufacturers like Britannia who are selling the same biscuits with the same composition.
Yes. Very well. Sir, Friday it will appear.
Grateful, my lord.
My lord, I was praying for your lordship.
My lord, it is there in item 373.
373 in the list?
Yes. New motion. It's new motion, my lord.
Yesterday only last.
All right, Friday it will be appearing as urgent motion.
Serve notice.
Serve notice.
Grateful, man.
My lord, I was praying for your lordship's leave to mention a very urgent matter, my lord. My lord, there is a tender which is to be, my lord, bids are to be opened on the 3rd of January. I am, my lord, the selected L1 bidder.
3rd of January?
3rd of February, my lord, I'm sorry. 3rd of February. I am the selected L1 bidder in respect of the same items. Well, there was a negotiation. Thereafter, I had reduced the price. My offer has been kept valid. But for the same items, the railway authorities have floated a new tender that they're opening the bids on the 3rd of February. But I was praying for leave to effect short service and to come back before lordships, maybe tomorrow or day after, if it's possible.
Tomorrow it's not possible. You can come on Friday.
I will do that, I will do that.
Serve notice and ensure that your other side is present.
I will do that. I will do that, certainly. Very grateful.
May I have your lordship kindly to mention a matter for extension of interim order.
When is it expiring?
31st of October.
Well, might have your lordship indulgence.
31st, I'll be in some personal difficulty. Could it appear tomorrow sometime?
Very well, give. Let us serve notice upon the other side.
Oh, may I have
to mention a matter where my
1 minute, yes.
Well, might have your lordship indulgence to mention a matter. The matter is relating to selection of dealership of Indian retail.
Where is the matter?
Of Indian Oil Corporation.
Where is the matter?
They have selected on the basis of
Where is the matter?
Matter?
Where is the matter?
Matter, my lord, it is appearing item number 1812 to a monthly list of your lordship list. If your lordship there selection on the basis of the fake certificate.
I will not upgrade it. Come on next working Monday. First day. No.
Very urgent matter because they are already selected.
For 2 days it will become infructuous. For 2 days will it become infructuous?
No, not that.
Then
not today. Your lordship will take up
Come next month,
My lord,
first Monday of the next month.
I'm praying for extension of interim
Monday of
order
next month.
Expiring on,
31st of January, my lord.
they will give.
Well,
Mentioning
I'll
upon
mention,
notice, my lord.
I'll mention on
That-
Monday. Next month, Monday, I will mention it, my lord.
Well, may I have your lordship's leave, let?
Order which is expiring on 31st of January.
Well, may I have,
Of notice.
may I have lordship's leave, let? Item number 98 and 99. Your lordship may recall, let, last week, let, the matter was adjourned at the instance of the, let, Mr. Obratos Mujibur was seeking adjournment. Since the copy was sub letter. Mr. Sengupta and Mr. Bhattacharya was appearing. It's an urgent matter, let, where mining is being started, let, without, let, environmental clearance, let. That was the urgency, let. Lordship may recall, let, that
It is there in the list.
they are in the list, let, unless my matter is taken up, let.
Yes, but in the urgent motion bundle, it is there.
But it's in item number 98 and 99. But today the matter will be taken up. Item number 10 possibly.
Yes, what
Unless it is
can be
matter-
done?
This leave was granted because of what just on 5th February. A third party right will be created.
Friday, put it as urgent motion. Serve notice.
Large scale illegality in the government recruitment process, where the wards of the present employee and departmental candidates were given undue preference.
But then why recruitment process before this time?
I was the chairman of the examination committee. I have written to the nodal ministry for taking up the matter and inquire into the matter. But against my representation, the nodal ministry as on date has not taken any steps.
But recruitment matter, why before this
Since
bench?
it is not my individual right which I am invoking, it cannot be termed as a service matter under Group 6. I'm seeking I'm invoking my right against the authority. So perhaps subject to applicable Group 9.
I am not accepting your prayer. Let it remain where it is. Yes.
Let the matter be listed at least.
No, sorry.
Lordship, may I kindly be permitted to mention this matter for inclusion, Lordship?
No inclusions.
Lordship,
My lord,
this
may
is
I-
running monthly list of
Come when inclusion
My lord,
matters
may
are
I
taken up.
permit to mention on appellate side matter, my lord, 558. My lord, this is
For upgradation.
an intellectual property matter, my lord. It should be, my lord, before the Justice Kapoor, my lord. Should be released, my lord.
Very well. Item
558, my lord. I have written.
558 of the combined list. Release for want of determination.
I beg pardon to mention, my lord, for inclusion in the new election.
Your personal matter.
No.
Then where is your band?
Oh.
She may be
Yes.
permitted to mention the intermediary is expiring on 31st of January.
Give.
No,
One,
my lord, non-prosecution, my lord.
Non-prosecution give.
one matter released for the cooperative bank.
Item
565 monthly list. 1,565.
1565.
565.
1565 released for want of determination.
My lord.
Lord, may I be permitted to mention one urgent motion, my lord. Petitioner had participated,
Where is the motion?
my lord, in item number 366, my lord, daily list of your lordship, daily list, my lord. Daily list as item number 366.
No upgradations.
My lord, kindly hear me once, my lord. Petitioner had participated in a e-auction process and petitioner had paid. Petitioner was declared as a highest bidder, my lord, and petitioner had paid all the bid amount within time, my lord, except 1% poundage, and my lord, therefore petitioner declared cancel the bid amount.
Yes. If something you have not done, if your bid has been cancelled, what can be done?
All the bid amount paid within time, my lord. Only
Yes.
1% poundage, my lord.
So 1%, please wait. Yes, madam.
My lord, item number 44, today's list, my lord. There is a settlement of bank and the petitioner. And the bank proposal of settlement.
What you want, tell me.
The last date, the last date is paid, my lord, 31st January.
Last
Last date.
for?
Settle, pay. Bank said that 14 lakh paid within the 31st January.
You have paid it.
My lord.
So
The amount, the case is still running, my lord.
let it run. You go and pay your dues. Who's stopping you?
No, my lord, the affidavit exchange, my lord. On the last date, order directed the affidavit exchange, my lord.
I cannot follow.
Lordship,
Yes.
may I be permitted to mention one matter? It is running in the daily list today as item number 65 and 66. The matter pertains to
Why are you mentioning?
Lordship, it's a very urgent matter, Lordship, because
Please wait. Yes.
May I permit to mention regarding the combined list, my lord? It's a very urgent matter, my lord. Petitioner, after superannuation, petitioner deposited the money to the post office, my lord, for MIS, but till not show the SB book, my lord, interest, my lord. Kindly, petitioner 75 years old, my lord. Kindly.
May I be permitted to mention?
When the upgradation mentioning is taken up, then please mention. Call the list.
May I have
Kindly to mention this matter.
one matter, restoration application.
No.
Well, I'm for the petitioner.
Permitted to mention for the inclusion of.
No, sorry. Yes.
Mentioning one matter which was filed before this Honorable Justice Kaushik Chandra. So after Puja vacation, so the matter was out of list.
Yes.
So I am mentioning this matter to.
No.
My lords, kindly to mention this matter.
It was due to appear on 27th, my lord.
My lord, item number
Lord, the matter-
65.
Yes. Who's for the petitioner item 1?
I am for the petitioner. My lord, this
Yes.
Hearing for the respondent number 1.
bank has, my lord, yet not filed a reply. And my lord, may I, my lord, make one prayer before your lordship. My lord, actually, this is the my lord's order in that same matter. Day before yesterday. Please, my lordship. So, my lord, both cases may be heard together. My lord, there also bank has not filed a reply. My lord, here also bank has not filed a reply since more than 1 year stay is being getting extended. So, my lord, this matter is listed on 18 February, my lord.
The interim order in this matter.
My lord, one thing is
Which bank is over involved?
this is my Axis Bank and in that there's my ICICI Bank. My lord. I say, my lord, both cases may be.
We are appearing for Axis Bank, and your lordship, as I have communicated to my learned friend, that we will be serving the copy today itself to them, and we will be filing it by tomorrow. It just needs to be affirmed, your lordship.
Both cases are on the, my lord, same report of the same issue. If your lordship may tag together, my lord, that will be better.
I am appearing for the respondent number 1, the RBI, my lords, in this matter. We've already filed our affidavit in opposition.
They have filed it, my lord. They have filed
All right,
only this.
please
Is
come.
for the limited period, my lord, stay be extended till hearing.
January, the other matter did not appear. 949.
No, they have prayed for extension and a matter listed on 18 February by your lordship.
18 February.
18 February. That.
All right. So I'll place this on 18th.
Yes,
also.
both the cases, till that the interim order may be extended. Parliament.
All right. The interim order that is subsisting in the matter is extended till 28th of February 2025 or until further order, whichever is earlier. Stop. On the prayer of the learned advocate representing Axis Bank,
Respondent number 2 and 3.
comma, the respondent numbers 2 and 3, comma, time to file the affidavit in opposition is extended till 31st, this Friday. Stop. Let the matter appear in the list on the 18th
My lord, 18th February.
of February 2025. Stop. Reply may be filed prior to the adjourned date.
My both matter be heard together. My.
It will be.
Yes.
Let it appear on the same day. We'll pass
Yes,
on
my
this. You can take
I'm
back
grateful,
this
my.
order.
I'm grateful, my.
এটা ফেরত দিয়ে দিন। হ্যাঁ, নাম্বারটা রেখে দিন একসাথে।
949.
Well, I am for the petitioner, my lord. Well, both matters, my lord, together, my lord, because your lordship can remember in the month of April in the last year, your lordship, my lord, consider the two added petitions, one filed by my learned friend and another filed by my client, my lord. The related to issue was, my lord, the redevelopment of the property and, my lord, the ultimate rehabilitation of my client. That was the direction your lordship, my lord, passed down in terms of the agreement it is to be provided. And, my lord, that undertaking was given, that is recorded by your lordship in the order. But despite that period, my lord, the ground floor has already been constructed, but they are not able to provide me because my lord, they have now, my lord, made another construction in the sanctioned allotted portion. Another construction, they got it allowed, my lord, detention, and my lord, they paid the fees. Therefore, my lord, in my respectful submission, my lord, they are unable to provide in terms of the undertaking recorded in your lordship's order. And on that basis, the lordship, my lord, permitted me, my client, to go to a, my lord, the temporary place to run my meat shop, and my lord, they were asked, my lord, to construct a building. Now the position is this, my lord, 4 months are provided in the agreement. Now the 6 months after the order, my lord, 9 months have elapsed. I requested them to give it. If you cannot complete the ground floor portion, my portion I will, my lord, complete. You also said with equal frontage, length and breadth should be the same in terms of the agreement. But because two, my lord, the orders, common orders are
Sir,
passed.
today is the first date.
My lord, my lord.
Please serve.
My lord.
The Who are they? These are the private parties,
Private parties
condemners.
are the petitioners in one case and respondent in another case. They are the owners of the building.
All right. Third, contempt for state service. List on 17th of February.
My lord. In both the cases, your lordship not direct because I have filed my two because of the two lead petitions. The same order be passed.
Same order in 3.
17 matter to appear, my lord.
Yes.
Yeah.
But I appear for the petitioner, my lord. Lordship will kindly take your lordship's last order. My lord, on 3 occasions, the state has taken time, rather they have not appeared. And they were supposed to take instructions and produce the instructions before the lordship. This is regarding release of incentives. We are at stage 1, where, my lord, the Commissioner of Sales Tax has to issue certificates certifying the amount of tax paid for a particular financial year. My lord, this is going on for quite some time. I don't know.
I am appearing on behalf of the respondent number 3, my lord.
My lord, they are
3.
My lord.
My lord, this is, my lord, this is going, my lord, this is 3 is WBIDC, I believe.
What about the state?
My lord, this is unbelievable, my lord. My lord,
You served the AOR?
Many times, my lord, last time also we have served. We have communicated your lordship's order.
Why is it
Your
that
lordship was
nobody's
pleased to
appearing?
pass a direction.
In which matter is Mr. Dinda there?
Yes, your lordship. Yes, your lordship.
This matter?
Yes, your lordship. Your lordship, I appear on behalf of the state, your lordship.
You cannot be heard, Mr. Dinda.
Am I audible, your lordship?
Yes.
Yes, your lordship. On the last occasion, our notice was served, your lordship. That is true, in fact. Your lordship, this matter is corresponding to 2000 scheme, a scheme of 2000.
The
That
matter is yet to be heard on merits. Your presence is required.
Apologies,
get
your lordship.
Instructions.
Your lordship, I don't have the written instructions as of today, but I have been communicated a few things. If your lordship pleases, I can submit the written instructions day after any day. I have received the
Any day
oral
means the
instructions.
matter is being adjourned day after day because you all are not
I know.
appearing, and now you say you can submit any day.
Your
File it
lordship,
today itself.
Well,
lordship,
and the copy of the instructions may be forwarded to us as per your lordship's direction.
your lordship, if your lordship sees there was a difficulty with annexure P6, the petitioner responded to that. On the last day, it was adjourned because no one appeared on behalf of the state, your lordship.
You are there for the state. It is for you.
Yes, your lordship. Your lordship, there has been some delay on the part of the department, your lordship. If that can be condoned, and a report will be filed, your lordship, to this effect that the scheme upon which the petitioner is relying or has filed a petition, that scheme is itself before challenge in another matter with regard to the same parties. I will get the details. I have, in fact, I am the AOR in that matter also, your lordship. The appeal has been filed by
Is
me.
my learned friend referring to the earlier period matter relating to electro steel?
Yes, your lords. Yes.
There is an order. The judgment has been delivered by my lord, Mr. Justice Bhattacharya, in favor of the petitioner. Contempt petition is pending. My lord, the state and WBIDC have preferred appeal. The appeal is yet to be heard.
Yes.
State's appeal has a section
Has
5
a delay also. Yes, your lords.
I will come to that. I will come to that. Since my learned friend is taking that point, I must address that point.
Your
Now,
lordship,
what has happened on 7th
before Mr. Majumdar starts,
before Mr. Majumdar is returnable on 7th. And my lord, the appeal is appearing before the Honorable Chief Justice in the daily list or something like that.
Yes.
The appeal is yet to be heard. And my lord, the Honorable Single Judge, Justice Bhattacharya, has made it clear that some compliance has to be shown on or before 7th. My learned friend should be aware of this.
Your lordship, 7th of February. Your lordship, I was coming to that.
We are at 2 stages. Mr. Dinda, will you please allow me to make my submission?
Your lordship, let me complete my submission, your
No,
lordship.
no,
Mr.
The
Majumdar
petitioner has not started even.
Yes, my lord. May I just indicate to your lordship what is the
Period.
what is the reason for approaching your lordship in this case? This is a subsequent period. My lord, we have made application for, my lord, eligibility certificate has been granted for release of incentives. There are 2 stages which are to be, my lord, followed for the release of incentives. Stage 1, my lord, I pay the taxes. I mean the commercial taxes, sales tax or VAT. And my lord, So for example, my lord, I pay taxes for the financial year 2011, 2012. I'm just giving an illustration. After the end of that financial year, the Commission of Commercial Taxes, now it is Commission of State Tax, would issue a certificate which will be provided to the petitioner as well as to the, my lord, WBIDC for release of incentives. My lord, for the prior period, the state had issued certificates for the prior period. And the writ petition was based on the fact that the state has issued the certificate and certifying the amount of taxes which have been paid. So on the basis of those certificates, my lord, incentives are to be released. The Honorable, His Lordship, Honorable Justice Sabushaji Bhattacharya was pleased to allow our writ petition. Now, this for the subsequent period where, my lord, the Commission of Commercial Taxes is yet to issue the certificates, certifying the amount of taxes which we have paid. So
But everything is on record. Why is the delay in issuing
my
the
lord, money, my lord, the funds are to be released.
Okay, the moment the
Moment, my lord,
certificate is
the
issued to you,
moment, my lord, the certificates are issued, my lord, on the basis of the certificate, WBIDC, which is the disbursing agency,
has
as per
to
the scheme, would have to release the incentive in favor of the petitioner.
the
It is a-
period for
the
which
period
the
involved,
certificate
my
is
lord, 2015 to 18, fraction of 2000 financial year 17-18, because, my lord, by that time, from July 2017, my lord, the VAT has, GST has come into play. So prior to the commencement of GST, we are entitled to incentives. We are not entitled to incentives after the commencement of GST. But that's an admitted fact. That's an admitted position of law. So, my lord, in that view of the matter, our simple prayer before your lordship was that the Commission of Commercial Taxes should issue the certificates.
Yes.
Because they cannot deny that we have paid the taxes.
Now,
Returns are filed.
now, may I just make a if Mr. Majumdar has finished? Sorry.
My lord, only one submission. My lord, their case is that the appeals, two appeals have been preferred against the order passed, judgment and order delivered by my lord, Mr. Justice Bhattacharya. The first one was preferred by WBIDC. My lord, the state preferred appeal only after issuance of rule. When this state preferred appeal, my lord, the learned advocate general is appearing in the matter. Learned advocate general, in my presence, mentioned the matter before the Honorable Chief Justice and Justice Hiranmaya Bhattacharya. Now, my lord, the matter was appearing in the list of the Honorable Chief Justice and Justice Hiranmaya Bhattacharya, but the matter is yet to be heard. My lord, we made categorical submissions before the Honorable Single Judge, my lord, Justice Bhattacharya, that there is no stay, so there is no impediment in, my lord, release of incentives. And that contempt petition has been made returnable on 7th of February. This is the current situation.
Yes. Your lordship, just 30 seconds. Just
1 minute. Tell me, what is the ground for preferring the appeal?
But in the petition,
State's
they
appeal?
say the primary ground is that, according to their perception, that is their reading of the eligibility certificate, that we were required to make investment of X amount, and I'm not giving the amount, I will give the amount later. We made an investment of Y amount which is lesser than X. So we are not entitled to incentive.
No, incentive is a different part, but the certificate comes first.
Certificate, the first is the eligibility certificate.
Yes.
That has been issued. And the eligibility certificate has been issued by the competent authority. On the basis, one of the condition of eligibility certificate is that the Commission of Commercial Taxes for every financial year would issue a certificate certifying the amount of taxes paid by the assessee dealer or the petitioner in this case. Once the certificate is issued and a copy of the certificate is forwarded to the disbursing agency or the nodal agency, being WBIDC in this case, WBIDC would release the incentives in terms of the special package. These are all special package units. This is a fact.
Yes, your lordship, may I?
Yes, state.
Your lordship, my appeal might get dismissed without the delay being condoned. My appeal might not be allowed. My appeal might not be entertained. But the
Tell
scheme
me
under
the court is not considered with the appeal. Why is the certificate not being issued?
Your lordship, because the scheme under which the certificate has to be issued, that scheme itself has been challenged. The scheme itself is at challenged before the Honorable Appeal Court. I admit whatever Mr. Mujumdar said, that there is no stay, the contempt order is allowed to proceed. Some compliance should be given, but I have time till 7 February, Your Lordship. The
Listen,
incentive and
if try to understand, if somebody has challenged a scheme, that does not mean that the scheme becomes non-existent.
no, no, no.
The scheme is there. Why will you not issue the certificate?
Your Lordship, because under the scheme under which the certificate has to be issued, that scheme is itself before challenge itself for challenge, Your
Lord,
Lordship.
kindly take the grounds of appeal. I have got the grounds of appeal.
Your Lordship, just one humble indulgence, Your Lordship. Whatever I said is in oral. Kindly keep it tomorrow. At least I will have the written instruction. Then Your Lordship can pass whatever orders Your Lordship pleases. Only this much, Your Lordship.
The petitioner prays for a direction upon the, who will be the authority?
My lord, it will be, my lord, Commissioner of State Tax.
Yes, tax.
Acha,
Commissioner of
the
Commercial Taxes, which is now,
Commission
my lord, Commissioner
four.
of State Tax.
Acha, the Commissioner of Commercial
This point number
Taxes
4.
for issuance of the payment certificate under
May I have Your Lordship kind leave, Your Lordship?
incentive scheme, 2000 for the period 2015-2018. Stop paragraph. Learned advocate representing the state respondent seeks time to take instruction. Stop. Let written instruction be obtained from the Commissioner of Commercial Taxes.
Now, my lord, Commissioner of State Tax.
But then you have not
My lord, this is
made the proper
new nomenclature given. That is all. My lord, it is the same. I think Mr. Dinda will not object to that.
Commissioner of State Taxes. State taxes. As to why the certificate as sought for by the petitioner is not being issued. Stop. The instruction shall positively be obtained by Friday, 31st. Let the matter appear in the list on 6th February 2025. Stop. The instruction shall be circulated.
Grateful, Your Lordship.
Learned advocate representing the petitioner.
Grateful.
Grateful, my lord. Grateful.
In this matter, my lord, I am waiting for the petitioner, my lord. But the service is not fully complete, my lord. We have served day before yesterday by speed post. My lord, may it appear on 5th, my lord, so that I can serve them another notice, my lord. Your Lordship was kind enough
My lord,
to leave, my lord.
I appear for the respondent number 4, one of the respondent. So I have
They
only,
are local, my lord, they may have been served. Only 3 persons have been
yes,
served, my
very
lord.
good. Let them
Your
complete
Lordship.
the service. My lord, I have only one indulgence, my lord. If it could be on the 7th of February instead of 5th,
Respondent number-
I am the respondent number 4.
My counsel is on virtual platform, my lord.
Your Lordships, in this matter, if I may, the main release are against IDBI. There are connected matters. That's on the 5th. That is why we are requesting the 5th, Your Lordships. On the 5th, only we will be able to give you a flavor of the matter. In fact, just for context, Your Lordships, at 10:50, the Honorable Supreme Court has just pronounced its verdict in this matter. There's a connected matter on issues of law. So if I may request 5th, Your Lordships will be able to assist the court. After that, if Your Lordships give any other date, so be it.
My lord, I was only saying that this flavor could be given instead of the 5th on the 7th. That's all I am praying for.
Can I
Because there
request
is
the
some
6th, Your
difficulty on the
Lordships?
5th.
6th, if it's possible.
My lord, if 7th, my lord, only difficulty that I have also have instructing advocates will be traveling from Delhi. So if it is on the 7th, my lord, I find my learned friend is not unnecessarily inconvenient because he is appearing on the virtual platform.
Matter list on 7th.
Deeply obliged, my
Service in
lord.
the meantime.
Deeply obliged.
The service has been effected. I shall give fresh notice, my lord.
Whatever.
My lord.
Yes, 6.
I'm grateful. I'm grateful.
But this is coming up for hearing after exchange of affidavits. We're taken by a little surprise that it suddenly appeared. At least we did not even mention the matter. There was an interim order which is there, it's been extended from 2022 regarding identification of the petitioner as a willful defaulter.
এটা কি নিজে নিজে এসছে কেউ মেনশন করেছে কে মেনশন the department directly.
If it could be on any other day, my lord, we'll come back and.
I'm praying for some time after 5th February, Your Lordship. I'm being led
Let
by
me see
Mr.
the
Ajay.
file. Are the pleadings over?
Yes, my lord, the pleadings are over. It's otherwise ready for hearing. My lord, we can file our reply. We've served an advance copy on the respondent.
Who are you
I'm
representing?
waiting for the respondent's bank, Your Lordship.
Respondent bank. Only one respondent.
Yes, sir.
State Bank of India. All right. When do you want the matter to be fixed?
So he wants it after the 5th of February. Any day after that, my lord. 13th or 14th of February, if you could come back.
By consent of the parties, list on 14th for hearing.
Look, the interim order is there from 2022 until further orders. This should
So
not
it's
be
still-
construed as an order. That's my only.
The interim order that is subsisting will continue until further orders.
Very grateful.
Grateful.
DVO. ODVO.
My lord, number 1 of
My lord,
appellate side.
this matter, my lord, I appear for the petitioner with Mrs. Paushali Banerjee, my lord. My lord, this matter was taken up for consideration, my lord. 24th, the other matter, my lord, pertaining to the same issue, my lord. The only difference in the cause of action is, my lord, a tender was floated, and my lord was kind enough to dispose of the petition, my lord, by your lordship's order dated 24/1/2025, and my lord, directing the answering respondent to consider the case, my lord, with regard to, my lord, the grievances raised before your lordship. Be that as it may, my lord, questioning, my lord, the earlier writ petition.
Mr. Basu, the matter has not been called on.
Let him continue. Let the file come. No difficulty. Yes, please continue.
My lord, this writ petition has become infructuous in a way by reason of the order passed by your lordship on order dated 24/1/2025. Your lordship was kind enough to dispose of the writ petition by directing the respondent authorities to decide the issue of sand mining tender, my lord, and without considering our tender, my lord, the authority should not proceed. This is the tenor of the order, my lord, in substance, subject to what my learned friend says. My lord, in this writ petition, which is in item number 1 of the appellate side, this, my lord, in this writ petition, my lord, my client, my lord, has ventilated his grievances with regard to, my lord, the climate as that was prevailing, under which, my lord, he was prevented from, my lord, lifting the sand as per his the allotted quota. Today, my lord, all the grievances, my lord, have lost its contemporaneous tone by reason of the subsequent order. So this writ petition is, my lord, infructuous.
Very well. Please come. It has been submitted by the advocate representing the petitioner that the instant writ petition has been rendered infructuous in view of the order passed by the court on
24/1/2025
24th
in
January 2025 in
WPA number 281 in WPA number 978 of 2025.
978 of 2025.
In view of the above, the writ petition stands dismissed as infructuous. You are for the authority.
I am for the mineral development, which authority invited to tender in the subsequent writ petition.
Very well, very well.
Lordship has
Next.
already passed direction. Great.
Deeply obliged.
I'm the writ petitioner in the matter, my lord. Lord, we are enjoying an interim order, my lord, which is to be expired on 31st of January, my lord.
But in this matter, my lord, the matter has been, my lord, heard by the bench more than several times, my lord. Each and every occasion, my lord, report has been filed, and my lord, everything has been, my lord, the matter is ready for hearing, but they have mentioned the matter when the interim order has going to be extended. And my lord, so far, my lord, in this matter, my lord, may I say only one thing?
The matter is extended till 30th of April 2025 or until further order which
And your lordship kindly
earlier.
fix the matter, because my lord, they are enjoying the interim order without any
Granted
legal
to the parties to mention the matter for hearing before the bench having determination.
Much obliged, my lord.
Yeah, just may it please your ladyship, I'd like to appear on behalf of the petitioner. My lord, the interim order which was passed by your ladyship on the 19th of
Who's your
December.
other side?
My lord, I have served notice, my lord. Mr. Mahata was appearing, my lord. There was an order, my lord, directing us to file the exception also, my lord, to their affidavit. Now, my lord, we have affirmed an exception, but in the meantime, there has been certain developments. Now, my lord, the persons, my lord, associated with this particular panchayat, now they were once again implicated in a false criminal case, wherein an order now has been passed by the Honorable Justice Tithankar Ghosh that no coercive action should be taken. So they have finally been able to come back to Nondigram, and we have discovered, my lord, certain other documents, my lord, which are very, very relevant. My lord, this pertains to, my lord, construction of the godown, which has been now, my lord, encroached upon by the police authorities. My lord, I can file the exception, or if my ladyship, my lord, grants me leave, my lord, I can, my lord, file a composite exception, my lord. Because if I file this exception also, my lord, I'll be seeking for leave, my lord, to file a supplementary exception. Because those documents are extremely...
Supplementary exception or a supplementary affidavit, because these facts are not on
No, a
record.
supplementary affidavit, my lord, to the my lord, in support of my exception, my lord. Because documents are there. Whatever they have disclosed in their affidavit, my lord. First of all, my lord, the affidavit was...
Did you serve this?
No, my lord,
Exception?
we are yet to serve this, my lord.
Then you prepare a fresh exception.
Kindly grant me that leave, my lord. And
Very
the
well.
interim order, my lord, is expiring on the 31st of January,
Please
my lord.
come. None represents the respondents.
Notice টা দাও যেটা serve করেছি।
The notice served upon the learned advocate representing the respondents. That's it.
Lordship, your lordship, I appear on behalf of the respondent, your lordship, state respondent.
Is the notice for it?
All right. তাহলে নানা পিয়াসটা কেটে দিন। ঠিক আছে। The interim order that is subsisting in the matter is extended till 30th of April 2025 or until further order, whichever is earlier. Stop.
Yep.
The leave is granted to the petitioners to file time to file the exception to the affidavit filed by the sixth respondent is extended till 14th of February 2025. Stop.
But there is only one fact, my lord, that requires to be, my lord, indicated. There was an order expressly directing the SP, being the sixth respondent, my lord, to file to affirm the affidavit. But what has happened is, my lord, I find, my lord, it has been affirmed by the additional superintendent of police, my lord. I will take that point, my lord.
In your exception.
This
Your
call
lordship,
for a rule.
the deponent has filed on behalf of the respondent number 6,
Oh,
your
this
lordship.
calls
Kindly,
for a
my
rule,
learned senior friend might create a confusion, your lordship. The order
No,
was
no,
done, the
it
order
is
was
not
duly
about creating
complied
a
by.
confusion. You should understand, you should appreciate once a senior advocate addresses the honorable court, he addresses about the position of law.
7th
So
March.
stop casting aspersions.
Don't get so excited early in the morning.
These are
Mr. Bhattacharya, that's
Item
excited.
Victor sir, my lord, going away very fast.
Yes.
My lord, item number 4, my lord, I am praying for short passover till 12:30, my lord. Mr. Joydeep Kaur has requested that the matter
It
may
cannot be
my
done.
my lord, he is
Cannot be done.
my lord, he is not engaged before another court, my lord.
Maybe.
Or not today, my lord, maybe.
That is different.
No,
But
lordship.
till 12:30.
No, my lord, I'm not till, my lord, or
No.
lordship, my lord, not then my
One minute, let me hear the petitioner. There is some urgency possibly.
Yes, lordship, yes, election is going on, lordship.
What is going on? Pharmacy council election.
Yes, lordship. So you are the last resort.
Yes.
For the saving the concept of democracy.
Yes.
This election. Not only that, for getting justice and removing the injustice in this election, lordship. Lordship, this is the affidavit of service. Kindly keep on record. Sir. Lordship, kindly
Lordship, kindly page 15, Lordship, annexure P1. Lordship, this is the election notice. As per the order or judgment dated such and such, MAT such and such, the Pharmacy Council modified the election notice. Actually, there was interfere of this court, Lordship, due to their bias, their arbitrary activities. So this is the modified election notification, Lordship.
Page?
Means, Lordship, so page 15.
50?
15.
15?
15, Lordship.
Yes.
So under the directions of this court, Lordship, this election is going on. This notification was published, Lordship. I am the next page, Lordship. Annexure P2, page 16, Lordship. Candidate number 4 is the petitioner. Lordship, page 24, Lordship.
1 minute. Publication of the ballot is 18th. Dispatch of ballot 23rd. Receiving the ballot, scrutiny of the papers. This is the Pharmacy Council. How is the voting made over here?
Sorry, Lordship.
How is the voting made? Does
Voting,
people come to vote in
no, no,
person?
no. Sending ballot paper to the
Sending
voters.
ballot.
Yes.
And the
Lordship.
ballot also comes back
Yes, Lordship.
through post.
Through post. Or maybe they will physically visit the place.
There is a place where the ballot box is there and the people can come and submit the ballot papers.
Yes, Lordship.
Now, scrutiny of the ballot papers and counting of votes will be commenced on 30th of January.
Yes, Lordship.
So the voting process is on.
Yes, Lordship. And
right?
Yes, Lordship.
From 11, results are expected by the 4th of February.
Yes, Lordship.
Yes. Now tell me, where is the difficulty?
Lordship, I am the petitioner, the candidate number 4, Lordship. Next
Candidate
page.
number 4, Shimanta Bhattacharjee, right?
Yes, Lordship. Lordship, come annexed P4, Lordship. Page 24.
Yes.
Lordship, line number 7, Lordship.
Page 24, what is it?
It is a newspaper report, Lordship.
Don't rely upon this.
No, no, I'm telling, Lordship, why I am telling.
No, you say what you've got to say, but not relying upon the newspaper reporting.
Definitely, Lordship. Lordship, my allegation is that, Lordship, there is a nexus between the returning officer, one nominated council officer, member, and the 6 candidates.
All right, out of 7, you are leaving 1. All 6 are
Yes, Lordship. Lordship,
having nexus with the election officer.
Yes, Lordship, I am telling you, Lordship. During the announcement of the name of these 6 candidates happened the office of the ruling party of the state, Lordship. At that time, in this press conference was present this nominated counseling member, Lordship. Respondent number 4, Lordship.
I did not follow.
Lordship, just Lordship, kindly follow the page 24, Lordship.
24.
Why I am telling you, Lordship?
No, I will not look at page 24. You've got to say something, you say.
Yes, Lordship.
Page 24, I'll not look.
Okay, Lordship. Lordship, the biasness has shows that the returning officer and the nominated person, the nominated council member, supported these 6 candidates in social media or whatever.
So where is the difficulty?
Sorry.
Where is the difficulty?
Lordship, if the referee shows his biasness, how I can play with a fair how I can face the fair
Others
election?
are coming and putting in their ballots.
Yes, Lordship. Lordship, during the campaigning, Lordship, they are clearly supporting them, Lordship. And I am announcing all the paper, Lordship, how they are supporting in social media, Lordship.
You also go and collect supporters.
Lordship, if the election who is conducting this election,
yes,
if he is not fair and he is supporting the other candidate, is it expected the natural justice?
What do you expect? The ballots to be opened and you can see whatever is there.
No, I am expected the neutral positions of the election officers.
What role does the election officer has got to play?
They are supporting clearly through, they are promoting them. They are promoting them, Lordship. The election officer, returning officer, promoting them.
Sorry, sir, the court
Lordship,
cannot
I
follow you.
am.
Who is the returning officer?
Lordship, respondent number 3, Lordship.
What post does he hold?
Returning officer, registered. Returning officer come registered of the Pharmacy Council, Lordship.
So he is holding the post of returning officer by dint of his designation?
Yes, Lordship.
And who do you want to take his place?
Lordship, I am praying any in this place any impartial person, Lordship.
What will that impartial person do?
Court whatever will decide, Lordship.
You tell me what is your prayer?
Lordship, Lordship, I am telling you, Lordship, annexure P3, Lordship, page 18, Lordship. I am submitting my way, Lordship. Page 20, Lordship.
See, you have to say either the voters are not being permitted to put in their votes,
I am telling
or
you,
they are not being permitted to submit their voter slip, or whatever, some allegation.
Yes,
somebody is
yes, Lordship.
supporting.
I have the allegation,
Show
Lordship.
me something.
Lordship, I am telling you all the allegations, whatever I have mailed before the returning officer, page 20, Lordship. Before
You have written a representation, page 20, to the governor, and you want this to be considered?
no, not only governor, Lordship.
Then
the returning
the
officer,
Chief Secretary, Government of West Bengal.
all the Lordship, page 22, Lordship. Kindly look my prayer, Lordship.
Show me a proper representation to who you have addressed.
Yes, this was before starting the election, but after declarations of the election, nomination process, and after that, whatever I am observing, I reported, Lordship, to the concerned authority, Lordship. During this election, Lordship, I have found that the identity of the ballot paper, the number, it is mentioned in the envelope. And not only that, Lordship, I just received few minutes ago, Lordship, the information from my client also that ballot paper dispatch, the voter will collect the ballot paper. This is the rules, but the candidate himself collect the ballot paper from the postman directly. There is a need of inquiry, Lordship. If this process is going on, Lordship, it is not expected that there will be a fair fee election and the result will come in fair manner, Lordship.
Who, according to you, would be the competent person to inquire in this
Lordship,
matter?
I am mentioned in the petition. I am praying that the Pharmacy Council of India has also the responsible for fulfill the basic theme of this act.
Show me the election procedure in this act.
So, Lordship, I am praying any impartial persons kindly give the responsibility to the Pharmacy Council of India, Lordship, to conduct this election, Lordship.
This is election of what? President, Vice President? Election of which post?
The 6 candidates, Lordship. The others member, Lordship.
The members of the pharmacy, not
Section
the
15, Lordship.
President and the Vice President.
No. Lordship, Lordship, Pharmacy Act, Section 15, Lordship. Section 19, Section 19.
In the act, is there any provision for lodging complaint against this election dispute?
Lordship, in the election rules, I have submitted
Yes,
a Xerox
Board
copy.
of
There is have the
election shall be conducted when dispute arises. Section 24, refer to the state government whose decision shall be final. Who is the competent authority in the state government to look into it? The registrar, registering officer. Election dispute, who is the competent authority?
the state government. The returning officer will decide regarding the validity.
Who are you representing?
My lord, I am representing my lord, respondent number 2 and 3.
What they?
My lord, they are the my lord, council and the registrar, my lord.
You are representing the
My
registrar.
lord. I am being led by Mr. Joydeep Kaur, my lord.
Yes.
Now, my lord, if I would renew my prayer that a short Passover, my lord has heard the
Why
petition.
you are there? Please make
Very
submission.
well, my lord. Then, my lord, I would start from suppression of facts, my lord. My lord would kindly take the order passed by the learned honorable coordinate bench on 26/12/2024, when after detailed hearing, this fact never came up before this honorable court, that the interim order was not rejected, my lord. Kindly see.
Sir, the file is here. I can see it is rejected.
Yes, my
He
lord.
may not submit.
Yes,
But
my
the
lord.
file is here. I
It
can
has
see.
rejected, my lord. The same
Then
submission
why
has
you
been
seek
made.
suppression?
Because, my lord, very well, my lord.
What very well?
My lord, this is suppression because, my lord, this was
Where
not.
is the suppression?
Ma'am, there is a fix
Very
the
well.
matter.
Very well, my lord. Let
Very
me now,
well.
my lord, because, my lord, the matter is being mentioned without any notice. We are after
No,
mentioning,
Lordship.
they have given us the notice. Therefore, after we informed the learned senior council, and he informed
I
us
have
he has some.
personally communicated with the senior council yesterday outside of
submission.
the court, Lordship.
My lord,
Make
kindly see, my
submission
lord.
on the basis
Yes,
of
my lord.
whatever is there.
My lord, kindly take the election rules, my lord.
Yes.
Kindly take the election rules. And my lord, kindly come to, my lord, rule 1F. My lord, rule 1F, my lord would find that who is the statutory authority to hold the election.
Yes.
It is, my lord, the registered and somebody appointed by the registered. Now, my lord, today the rule is not challenged before your lordship. Today, the statutory person who is the registrar, he is the only authority to hold the election. Now, my lord, if my lord kindly compare to the writ petition, where is any worthy allegation against the registrar that he has, my lord, campaigned or he is not, my lord, performing his duty? There is nothing. Only, my lord, bold allegation that the returning officer is campaigning, returning officer is helping the other. Here, my lord, I tell there is no, my lord, option for alteration, because ballot paper goes to the voter, it comes through post. Now, my lord, if in some cases it is not delivered, then the voter himself has to come or through his authorized agent, and he will take the ballot paper and he can he can, my lord, cast the vote then and there or by post. Therefore, the allegation that I have some candidates are collected from the post office has no legs to stand. Now, my lord, kindly see this matter, my lord. When the election has commenced, my lord knows that constitutional courts had also held that when the notification of election comes, thereafter writ courts should not interfere. I will rely upon judgments. Now, my lord, kindly come to rule 23 and 24. My lord, before that, my lord, I would indicate that this election is, my lord, is continuing by order of Honorable Division Bench presided over by the Chief Justice. But the Honorable Chief Justice was pleased to direct the state government to appoint an observer. A observer has already been appointed. The election is, my lord, is going on through the observation of this observer. There is no question of biasness. Now, my lord, kindly come to Rule 23 and 24. Why this writ petition is not maintainable at this stage? If any question arises as to the intent, no, this is, my lord, the notification. So, my lord, observer has
One minute. Did you intimate this biasness, the allegation that you are making before the observer?
Yes, Lordship.
It was intimated.
Yes, Lordship. He is also the party member.
Show me the
Lordship,
intimation.
page 22, Lordship.
Has any order been passed? Any?
No, Lordship. There was no order passed. There no
Where is the observer? Where is the observer's page 20?
Lordship. One second.
He has not sent any communication to the observer as I can see.
I did not find any.
Yes, my lord.
Lordship, I have. Second, page 24. Lordship, 20, page 20, Lordship, the Joint Secretary.
He has not approached the observer, my lord. The writ petition is, my lord, based on a newspaper cutting.
Show me the order of the court pursuant to which this election is being held. Where is the provision or the direction for engaging or appointing an observer?
My lord.
MAT 411. I have a copy.
Yes, MAT 411, right.
Which portion do I see?
Yes, my lord. My lord, kindly come to page number, my lord, 20, page number 23, paragraph number 24. I am further view that there should be an observer nominated by the government to ensure that the entire election process is conducted in a free and fair manner without any irregularity or complaints.
In the presence of the observer?
Yes.
Very well. Please come.
Lordship, page 23, Joint Secretary, who is the observer, Lordship. I send the copy forward. Even I have communicated over telephone also, Lordship, with the observer. He knows everything, Lordship. Page number 23, Lordship. Is the observer. Even I have communicated over telephone, Lordship. He knows all the facts and circumstances.
The petitioner is aggrieved by the manner in which the election in the Pharmacy Council is being conducted. Stop. It appears from the submissions made on behalf of both the parties that the election is being conducted
Lordship, I want to
in
submit
compliance of the
pen drive, Lordship.
Order dated 16th of April 2024, passed by the Honorable Division Bench of this court in MAT 411 of 2023. Within bracket, West Bengal Pharmacy Council and another versus Rusha Poddar and others. Stop. Paragraph. That's a judgment of the Honorable Division.
Lordship, I want to submit one pen drive, Lordship. Where is the content and how they are campaigning
19th.
the Sharkar Monolito Party.
না আপনি করুন 19th of May 2023. 19th May 2023. তো জাজমেন্টটা এখানে 19th May রয়েছে। এখানে তো অন্য একটা কিছু রয়েছে, জানি না। আচ্ছা, stop. The Honorable Division Bench, at the time of disposal of the appeal, was pleased to hold that the election should be conducted in the presence of an observer nominated by the government to ensure that the entire election process is conducted in a free and fair manner without any irregularity or complaints. The court directed the Secretary, Ministry of Health and Family Welfare Department, Government of West Bengal, to nominate a senior officer of the department to act as observer stop paragraph. The petitioner alleges bias on the part of the registrar of the Pharmacy Council
And one nominated council member.
and one of the nominated members of the council. Stop paragraph. Who is representing respondent number 5? You are 4. Representing respondent state. Who is there for the state? The respondent number 5, you should take responsibility. What is your instruction?
My lord, the instructions are, my lord, the allegations which he is leveling against are purely that there is nothing of that sort which is.
Did you intimate the petitioner that there is nothing in the complaint?
No, my lord.
Why not?
That has not been done.
You are acting in accordance with the court's order. Will you not intimate that if there is an allegation that the election is not being conducted in a proper manner?
Kindly allows us to take cognizance of the representation dated 20 at page number 20, and we shall dispose it off with his allegations.
My lord, here I
Lordship,
join
this
issue,
is
my lord.
the Lordship
But
kindly.
there is specific rule for this. What he is asking for, there is specific rule. That stage has not come. Rule 23 and Rule 25.
One thing, my lord.
Lordship, there is a several judgment when injustice has come.
Yes, yes.
Done. The state authorities can.
Only one line, my lord, may I add? I am for the nominated member. The allegation of bias. What bias is? No, nothing specific.
Lordship, this is the pen drive, Lordship. The content is available, Lordship.
Yes.
Detailed content. Kindly.
You make further pen drives. Forward one to the observer and next one to the Honorable Chief Justice who delivered this judgment. Right? I'll relegate it. আচ্ছা কি বললাম ঠিক আছে a notice demanding free and fair election was served upon the observer being the Joint Secretary of the Health and Family Welfare Department in December 2024. Stop. The same is yet to be considered. Paragraph. From the election notice dated 16th November 2024, published by the Registrar, West Bengal Pharmacy Council, being the returning officer of the election of the Pharmacy Council, it appears that the last date for receiving the voting papers from the electors at the council's office was 27th January 2025 till 5 p.m. And the scrutiny of the voting papers and the counting of votes is to commence on and from 30th January 2025 from 11 a.m. onwards. Stop paragraph. The petitioner prays for conducting an inquiry as there are gross illegalities in holding the election. Stop paragraph. Learned advocates representing the respondents opposes the prayer of the petitioner. Stop. It has been submitted that the writ petition is premature and the same is not maintainable at this stage. Paragraph. Without entering into the issue of maintainability of the writ petition, comma, as it appears that the election is being conducted in accordance with the direction passed by the Honorable Division Bench, where the court clearly indicated an observer to be appointed for ensuring that the election is held in a free and fair manner, and a complaint is pending consideration before the observer alleging illegalities in the election process. Accordingly, the instant writ petition is disposed of by directing the observer, being the respondent number 5 herein, to consider and dispose of the objection filed by the petitioner, dated 18th December 2024. After giving reasonable opportunity of hearing to all the necessary parties. Stop. Next. The petitioner has prepared the petitioner has collected certain information and data and has saved the same in a pen drive. Stop. It will be open for the petitioner to forward the pen drive to the observer along with the objection which was filed on 18th of December 2024. Stop. The observer shall pass a reasoned order and if it appears that the allegation made by the petitioner is proper, comma, then remedial measures shall be taken. Stop. Paragraph. The observer shall take steps in the matter at the earliest.
And before voting, publish of the voting result.
1 minute. The observer shall ensure that the objection filed is positively disposed of prior to the declaration of the result. Stop. Next. Till the objection is disposed of, comma, the result of the election of the Pharmacy Council shall not be declared. The writ petition stands disposed of.
My lord, the representation does not say that it has been sent to the observer or
It's-
the post, which is the joint secretary.
No, Lordship.
At the bottom, please come to page 22 at the bottom,
Lordship,
copy forwarded to.
The candidate inform over telephone also.
And I have given him direction to forward this representation along with the pen drive.
Not obliged.
But your lordship's not dealing with the maintainability point.
No. বইটা ফেরত যাবে।
বইটা নিয়ে
Lord, in 5, I beg to appear on behalf of the respondent.
My application, my lord.
Yes.
Short matter, I'll just take your lordship through 3 pages. Lord, actually dry plastic clips. Lord, I supply elastic railway clips to the railways as a tender that's floated. Lordship need me trouble with the papers, my lord. I'll just give a brief background and take your lordship to 3 pages. Well, elastic railway clips I supply to the railways. Railway floats a tender. I participate. I get chosen. I make the supply. My obligation to
Respondent number 1, who's there? You are there?
I am there. I am
Two also.
both of the respondents. Madam.
One is the answering respondent.
Yes.
But my obligation is to have the goods supplied and give a guarantee with regard to 30 months from the date of delivery, or 30 months from date of supply, or 24 months from date of delivery, whichever is earlier. The tender or the contract provides that beyond that, I have no further obligations. Here, after the period of 30 months is over, and these dates are admitted, I'll show the dates from the document. After the period of 30 months is over, they come and make an inspection. The inspection, I naturally don't participate because I have no further obligation under the contract. Then they pick it up, issue me a show cause notice. Then RDSO delists me from his list of approved vendors. I challenge that before this honorable court. They come and show there is an alternative provision for appeal. I am sent back to invoke that alternative remedy. I file the appeal. The appeal is now dismissed or disposed of with a one-line order. There, in my understanding, I have a very good case. That appeal is given by one-line order. But what RDSO seeks to do here is, if I seek a remand from your lordship and go back before the appellate authority, the period of delisting is 1 year. I have already suffered from September 2024. So till February, I'm gone. So
Yes.
I am basically suffering an order which is ex facie without jurisdiction. They referred to one RDSO guideline.
Was any opportunity of hearing given to you prior to passing this order?
Before the appellate authority, nothing.
Not the appellate authority, the
I
RTF.
had given a show cause. I had given a reply to the show cause.
All right.
But this is, I'll just take the point of jurisdiction. If I can't succeed on the point of jurisdiction, I'll come back to the aspect of one-line triptych order. Just the aspect of jurisdiction. Two things, if your lordship can kindly have a look at. I'm sorry. Kindly have a look at page 101. I'll trouble your lordship with one more page after this. 101.
Yes.
101 is a part of the agreement that I had with the railways. Guarantee. Clause 9.
Yes.
The contractor guarantees that the stores which he supplies shall be manufactured fully in accordance with the specification. In all cases, the contractor guarantees that the design shall strictly follow the as-made detailed drawing with such modifications as are notified in respect of each type. Kindly have a look at 9.2. The contractor further guarantees that the stores shall be free from defects in material and workmanship, provided that the contractor's liability in this respect shall be limited to arranging the necessary replacement of the defective supplies free of any charge, only to the extent that such replacement are attributable to or arise from faulty workmanship or material, or in the manufacture of the stores within 1 month from the date of issue of such notice of defective material. All replacements shall be made free of cost at destination. If the contractor so desires, the replaced stores can be taken over by him for disposal at he deems fit within a period of 3 months from the date of receipt of replacement of stores. After the expiry of this period, no claim whatsoever shall lie on the purchaser. Now kindly have a look at 9.41. And I stop here with this. The guarantee herein contained shall expire in respect of each item of stores on the expiry of 30 months from the date of its delivery, or 24 months from the date of placing in service, whichever is earlier, except in respect of defects notified to the contractor prior to the expiry of such date. So when can I be caught here? Within 30 months from date of delivery, or 20 months from it being placed in service. But within this period, if the defect is made known to me, then 9.1 will kick in, with 9.2 having my reciprocal obligation. One last document, Lord, kindly have a look at page 115. At the top,
Your Lordship will find the date 2nd of August 2024. Now, this is the date when the defects are being notified to me. There is a column, like a box, serial number 3, date of supply. Kindly see the dates of 8th of December 2021 and 19th of January 2022. This is their document. I give them the full benefit and give them 30 months, not 24 months. 30 months from 8th of December 2021 is 7th of June 2024. This I have looked at the calendar. This your Lordship will just take my version of it. And 19th of January 2022, 30 months is 18th of July 2024. I am not even troubling your Lordship with the 24 month date of supply. Simplicity on 115. If your Lordship now turns over to 116, so the cutoff date for 19th of January 2022, which is the later date, is 18th of July. Your Lordship has seen that. Kindly turns over to 116. Top 3 lines. The samples has been sent to RDSO as per report of RDSO dated 29 July 2024 after 30 months and has been rejected and is hereby declared as rejected. Now kindly see 116. This is where they ask me to replace. In view of the above, and they refer to clause 9 of the purchase order, the guarantee herein shall expire in respect of each item of stored 30 months from date of delivery or 20 more months from date of placing in service. And date of delivery is already 8th of this already mentioned. And then they say reply and supply replace. So the genesis or the source of this power to reject and call upon me to replace is 9.1 and 9.3. My obligation to supply is 9.3. Their right to call upon me to supply is within 30 months from date of supply.
What happened on the 4th of June 2024?
4th of June, some inspection has been, your Lordship will find location, representative jointly tested on 4th of June. This was inspection happened, they had taken it, was tested. I am being informed on 2nd of August in respect of a report which is 29th of July. I'm simpliciter going by own document. The date of delivery is also admitted. So post the 30 months, invoking clause 9, I have no obligation under the contract at all. But based on this, RDSO has delisted me. So here I say there's a jurisdictional error, because if your Lordship looks at the show cause notice, I'll just show that 135 is the notice to show cause. It's been paginated horribly, my Lordship will forgive me for that. Kindly have a look at 131. I'm sorry, 132. Just the first 2 sentences I'll place. Southeastern Central Railway intimated by so-and-so, supplied by your firm against PO so-and-so, have quality defects, excessive loosening and all of that. Joint inspection. Kindly have a look at paragraph 3 at page 132. You were intimated to deputy or representative. Letter dated 27 June 2024 and confidential 14th of August 2024. And now my failure has resulted in this notice to show cause. Well, my respectful submission before your Lordship is that if this is the admitted position and that is clause 9.1 and 9.4, then the genesis of the action is incorrect. You are foisting an obligation on me for which you are delisting me by applying a provision of a contract which has expired on that given date. And for that, I don't need to refer to a single of my own documents. I can just show their own document 115 because the date of supply is admitted. 30 months by calendar is before 2nd of August 2024. Now, what is the immediate urgency for which I need to trouble your lordship? My lord, apart from the fact that despite a jurisdictional defect, my lord, just to bolster my case, kindly have a look at how the appeal has been now dealt with. At page 161, but I'm on a slightly, I'll place my case slightly higher than 161, my lord. This is their rejection of my appeal. Has considered an appeal and against the auditor and so on so, and has decided that the order of delisting for 1 year should continue. Well, conclusions are not reasons. They have to give reason that if I fail on the first point, I'll fall back on this. But in my understanding, I have a slightly better case because this suffers from a jurisdictional error. And what happens is the moment I am a delisted vendor by RDSO, in none of these tenders I can participate. And just one judgment, your lordship will allow me to cite. This is reported in 2007, volume 8, Supreme Court cases, where the Supreme Court has held that my right of opportunity to participate in a tender process, 2007-8 SCC, page 1. My right of opportunity to participate in a tender process has now been recognized as a right under Article 21. This opportunity is being taken away by an order which possibly is without jurisdiction.
All these facts you...
Yes, Manoj. All of this was there.
It was there before
Yes.
the earlier writ petition also.
Yes, Manoj, we had gone up. We'd come up against this show.
After all this, you were directed to go to the appeal.
Before the appellate authority.
Right.
Now the appellate authority has passed this
what
order.
is the use of re-agitating all these things all over again?
So there, Milord, the court does not get into the merits because of an appellate alternative remedy. I have exhausted that and I've come here. So now I am...
Yes, I get it.
Milord, I'll just refer 2 pages. They are documents. First of all, Milord, kindly takes up that contract. I will once again read clause 9.4, Milord. Page 101, which speaks of, Milord. If you're 9.4, Milord. Page 101.
Yes.
Milord has found out. The guarantee herein contained shall expire in respect of each item of stores on the expiry of 30 months from the date of delivery or 24 months from the days of placing into service, whichever is earlier, except, that exception I'm harping upon, except in respect of defects notified to the contractor prior to the expiry of such date. So the obligation of the contractors is up to 30th months. It does not conclude there. If I have notified him of that defects prior to that completion of 30th months or 24th months from the date it was put in service, his obligation continues. That is the contract which I could understand, Milord. Now, Milord, kindly turns to page 100. They have issued that paragraph they themselves were relied upon. Milord, page 117. 117. 17. This is...
Yes.
Milord, this is the letter they have given to us, wherein we called for the replacement and they have given the reply. Now, Milord, 9.4 at the last, at the bottom, they have referred to as 9.4. That I'm not reading again. That clause has been recited. Milord, then Milord, kindly turns to the next page. We have reiterated that ERC, that is Mineral Electric Railway Clips, MB supplied against lot number this, has been received by the consignee between 3/12/2021 and 10/1/2022, and necessary complaint has been made regarding defective supply only on 14/8. This fact is not correct. Milord, I'll reflect to it. 30 months has already expired on 10/7. So according to them, so the period is 10/7. Milord, they have themselves admitted 10/7. So if something is put before 10/7, then the obligation continues. My lord, now, as from the date of receipt of the material. So any complaint made after 30th month from the date of its delivery is not tenable. Now, my lord, kindly turns to page 132, which my learned friend has reflected. My lord, para 2, later dated, their letter, my lord, we have written it to them, my lord, that is 28/24. What we have notified? A joint inspection was carried out on 4/6/2024. What is the inspection about? This is about that there is a defect. And within which time, my lord, before 10/7. So was they not intimated within that period span?
Show the intimation.
My lord, they have them.
Defect, my lord, so the
Please show
defect
the
intimation.
Please show the
My lord,
intimation.
joint inspection without intimation.
Inspection is something else. Inspection may be for many
Then, my
reasons.
lord, we have
Show
to-
the intimation that you communicated within the 30 months period.
My lord, then we have to file an affidavit. My lord, that I do not.
Show me the document.
My lord, document I am not carrying, my lord. That is the thing. The question was, my
You
lord
have it.
directed the matter to appear in the monthly list of February. That was the specific order of my lord. That order was passed on 15/1/2025. I have informed the client, but that document that we have intimated is, that I have not still now not procured. But my lord, that's fixed
Lord,
off,
my
my lord.
learned
That
friend
document
will-
has not been denied. This
No,
letter,
my
no,
learned
nothing
friend
has
will
been
read
denied.
out
That is,
132. It's his own document. The dates are given there. Apart from
my
this,
lord,
what
and in
document?
paragraph 8.
It
my lord,
mentioned
one
14th of August 2024.
Please.
And
I
page
have not
161.
objected when you have submitted.
1 minute. Page 161. Is this
My lord,
the way
one-
to dispose of an appeal?
My lord,
Page 161. No reply to this.
it should have been always, my lord. That I cannot deny. Some reasoned orders has to be passed. But what are the provisions? Whether reasoning has to be given, that provision we have to consult, my lord.
File a report. All right.
My lord, in one paragraph, my lord. I'll refer to paragraph 8, my lord. Paragraph 8
of paragraph 8 of what?
Of the application, the writ
petition.
petition.
Next inductor कब है also?
My lord, paragraph 7.
Yes.
Paragraph 7.
What does it say?
They themselves were admitted that they were called upon for the inspection. My lord, prior to
Listen.
4th June.
You cannot shirk back your responsibility. You were supposed to intimate. Show the intimation.
They have admitted, my lord, that they have been, we have given, my lord,
They were present. I take it that they were present at the time of spot inspection.
My lord.
Where is the intimation of the defect? Nothing more.
My lord, if they are present, my lord, then the intimation must be there. Otherwise, how could they be present? I'm asking this question to myself.
No, sorry, sir. The court is not here to answer your question, but then I cannot follow how you have followed your guidelines and your contractual terms.
Lord, I apologize for the interjection, my lord. The urgency with which we had mentioned, there is a tender that's going to expire on 31st of January.
But see what can be done.
But allows me, let them file the report, allows me to participate without prejudice to my rights and contention or their rights and contention. Let me participate, it will not get finalized, my lord.
But there will be other tenders also coming up. This
Lord,
will not be the last tender.
Well, this
And
is
they have
Railway
been registered
authorities.
for 1 year.
no, that 1 year I've already suffered
If it-
from September.
Yes, yes. That
Well,
is
this
not the
let
thing.
me participate. This is at the stage
For
of
1 year, that means he can be
I'm
debarred.
not
This
placing
is
that,
not the
my
way.
lord, but their
kindly
paragraph shows
considers
that they are
allowing me
called
to
on. They themselves have admitted that
considers
they were
allowing me to
present in
participate.
the inspection.
Second, allows me to participate in this tender, which is closing on 31st of
I'm
January
not-
2025. Let them come up with a report in the shortest possible time. Let me participate in that.
And what is this tender about? The same elastic?
Same, no different. Because I'm a RDSO approved and vendor, I can participate. The moment I get delisted, I've already lost 4 tenders. This is the
And
5th one.
this is this elastic rings and what clips?
No, this is something else that I manufacture.
Something else.
This is with regard to ERC
Elastic,
clips.
they make
Same ERC clips.
elastic clips.
ERC clips. So let me participate. Before they come up, I'm sure my learned
You
friend.
have that tender?
Yes, my lord. Yes, it's right
Let
here.
me see.
Am I to copy now?
The date of opening? Date of opening?
That copy
Kindly have a look at left-hand column. Date of closing is 31st January
Yes, I
2020.
can see. But then what about the date of opening of the tender?
Copy on nahi ekta.
My lord, that copy I am entitled to, my lord.
What
No,
copy?
that-
That
if
copy,
I
my lord,
only
has
have
asked for.
Certainly.
My lord, that copy should be supplied to me.
Commence 10 days of contract completion within 60 days. 30 months from the
কোথা থেকে
date,
দেখাও?
warranty period.
Please supply me with a copy.
এটা দিন তো ওনাকে।
Of course.
Look at this.
100%.
Look at this paper.
No,
Look at this paper. I
My lord,
was
I
trying
can
to
make a
find
Xerox
out.
and give it to my lord's court's office.
1 minute. I can find. I just tried to find out the date of opening.
Yes, mother, publishing date and time is 6th of January
That is
2025.
publishing. Opening of the tender. Closing date is there,
Yes,
but
yes,
the
yes.
opening date I cannot find.
Yes, no,
Offhand.
closing date is there, but I understand your lordship's query. Give me 1 minute. No.
লিখুন তো। The petitioner
এটা একবার দেখাও তো, আমাকে দেখাও। The closing date I don't find here. Closing date is the
Closing
opening
date
of the
is-
tender. No, ranking order.
closing is 30th.
Yes,
you
I
say.
understand your lordship's query. Just
But
give
when
me a
will
minute.
it be opened? So in the meantime, can the writ petition be disposed of? This is the query of the court.
I understand, my lord. When they'll open,
The date is not there.
that is not there.
Yes.
It just shows the closing date.
Closing date.
So if I can't participate, then my right is gone. I missed the bus. And I'm carrying 4 other tenders, my lord, which I've already lost because of this order. This, your lordship, will allow me to participate in at least, my lord.
লিখুন তো। The petitioner is aggrieved by the order passed by the appellate authority
Has been decided.
in response to the appeal filed by the petitioner. Order of the appellate authority dated 21st of December 2024. In response to the appeal filed by the petitioner, in compliance of the direction passed by the court on 7th October 2024 in WPA 25634 of 2024. Paragraph. The petitioner has been delisted by the respondent authority.
Delisting order কোথায়?
Stop. According to the petitioner, the delisting order is bad and not in accordance with the terms and conditions of the tender in which the petitioner participated. Paragraph.
Delisting order.
According to the what is this page 100 and 101 that you relied upon? Is this the contract or
Page 101 is a part of the agreement.
according to the agreement which the petitioner entered into with the respondent authority.
Some terms of the contract.
In terms of clause 9.4. The petitioner was supposed to give a guarantee in respect of the goods supplied for a period of 30 months from the date of its delivery or 24 months from the date of placing the service, whichever is earlier, except in respect of the defects notified to the contractor prior to the expiry of such date. Stop. Paragraph. From the documents annexed to the writ petition, there is nothing to suggest that the defect which the respondents found with the goods of the petitioner was intimated within the aforesaid period of 30 months. Stop. Paragraph. The authorities found the goods supplied by the petitioner to be defective and has delisted the petitioner for a period of 1 year. Stop. Out of the 1 year period, nearly 6 months are over. Stop. In the meantime, the appeal was preferred and has been disposed of by passing a one-line order without any reason. Stop paragraph. Prayer has been made by the petitioner to permit it to participate in the tender which has recently been floated by the respondent authority and which is due to close on 30th of January 2025. Stop paragraph. Learned advocate representing the railways submits that the
My lord,
petitioner
I'm representing
was
1 and 2, my lord.
Acha 1 and 2.
My lord, the railways is not a party.
Submits that that the petitioners were aware of the defects. Petitioner was made aware of the defects on the date of the inspection, which took place within the 30 months period. Stop paragraph. The learned counsel, however, doesn't have any document right now in support of the submission that the petitioner was intimated about the defect within the 30 months period. Stop paragraph. As it appears that the appellate authority has passed an unreasoned cryptic order and disposed of the appeal. Accordingly, the court intends to interfere in the instant writ petition. Stop paragraph. The respondents are directed to file a report by way of affidavit within a fortnight.
Some more date, my lord.
3 weeks.
4 weeks, my lord.
I will permit the petitioner to participate.
My lord, what can I submit?
This is
my
the
lord?
reason
I have to come with the rules, my lord. I have to consult because the matter.
not the rules. 1 page that you intimated, that is enough.
My lord, I'll come up. I will intimate. I will try to coordinate with my client and will intimate, my lord, so that the report can be filed within a specified
Within a
period.
period of 4 weeks. ঠিক আছে? The as an interim measure, the petitioner shall be permitted to participate in the ongoing tender process. So from the notice inviting tender, give me the number,
Yes,
please.
I'll just give the number. Tender number 612-45676.
Dated such and such. The date of opening the bid.
দেখাও আর কি আছে মুখে বলছো
Cannot be ascertained. Stop paragraph. The participation of the petitioner in the tender shall be subject to the result of the writ petition. Stop paragraph. The matter is made returnable on 10th of March 2025.
Look, there will be a
Tender data debe to ekkhuni.
Look, I can leave that on record, not a problem. So that lest there be any doubt with regard to it, let it be on record.
My lord, then direction be passed.
No, I will give it to him. Lord, my learned friend
They have not.
No, I'll give
Tender number to likhe nin. ডেটটা লিখে নিন। Published by the এটা হচ্ছে NF Railway. This is the NF Railway.
Yes, madam.
এটা
No, no.
py.cmm/e এটা লিখে নিন, এটা ফেরত দিয়ে দিন। হ্যাঁ, তা না হলে এরা আবার ইয়ে করছে।
The affidavit of service we.
Yes, service is taken on record.
I'm very grateful, madam. She is very kind.
Lordship, before starting the next item, Lordship, pardon me, I am disturbing in this manner, Lordship. You just passed the necessary order of item number 4, Lordship. Just kindly give the liberty to the petitioner to communicate with the server copy, Lordship.
Yes.
Our Lordship kindly kept on the record of the affidavit of service, which was the direction of the section.
আগেরটাতে affidavit of service টা রেখে দিতে হবে।
Much obliged.
আর কি বলে?
Item number 4.
Parties to act on the basis of the server copy. একটা প্যারাগ্রাফ এটা সই করে দিচ্ছি।
But I'm appearing on behalf of respondent number 3 and 4. Before my learned senior friend opposite starts, I have a preliminary objection with the maintainability of this writ petition.
Maintainability.
My lord, I'm also appearing for respondent numbers 1 and 2 for Reserve Bank of India and the Foreign Exchange Department of Reserve Bank of India. And I also raise the same issue because the writ petition is not maintainable. Also, along with the point, I'm today a little handicapped because this writ petition was served only on Monday evening, late in the evening. I don't have a copy of the writ petition before me, but I have received the instructions so as to assist your lordship, because there was a connected writ petition filed in this matter, which is appearing in the monthly list of
I believe the RBI has been served.
as item number
I have no objection
1855.
to meeting the.
So that is WP number.
The Lordship will hear the facts for a few
RBI
minutes.
is served, my lord, but only.
Let me hear what it is about, then
Yes.
the maintainability issue can be taken care of.
Very well.
Just kindly have this. Just please have the list of dates, which is very brief and will save a lot of time. Now, under LRS, give another copy. May I hand up
Yes,
to my lady a list of dates?
Yes, please.
Under LRS, I'm allowed to take out money and to a foreign account and invest it or whatever. I took money under LRS, deposited in a bank in Singapore to do trading in securities and stocks, which is permitted. There's no complaint about that. The bank advanced some monies to me, and my money and the bank's loans were used for trading. And then at the end of the 2-year period, the bank's debts were paid and the money repatriated to India along with the principal, and the profits and taxes were paid. There is no complaint about all those transactions. There's no complaint about PMLA, no complaint about. The complaint is, before I took a loan from the bank, I should have taken permission of the Reserve Bank of India. Now, without going into the merits, I'll deal with that if necessary, without going into the merits. On 18/11/22, would your lordships please see the list of dates? It saves a lot of time. Show cause notice was issued by the Special Director, Enforcement Directorate. On 21/23, I filed my first compounding application to the RBI, which is the compounding authority. When there's an allegation of a contravention, I can file a compounding. On 8/1/24, the first compounding application was returned, giving a reason that you have not furnished all the information. Liberty given to file fresh compounding application. On 28/3/24, the adjudication order is passed by the Special Director, Enforcement Directorate, imposing a penalty of 10 crore, which is what is being challenged before your ladyship. 10/5/24, I file a fresh compounding application to the RBI, and I seek a personal hearing, which is allowed under the rules. On 11/9/24, the fresh compounding application is rejected by the RBI and returned as not maintainable. And the sole reason is that a compounding cannot be done once an adjudication order is passed. That is the issue before your lordship. I will demonstrate to your lordship that after an adjudication order is passed, you can file a compounding application. That is the act and the rules. I'll demonstrate that in a few minutes. Then I filed a writ petition. After I filed the writ petition and before it could be listed for hearing, the assistant director issued a demand notice saying, please pay the 10 crore. Therefore, I amended the writ petition. I filed a fresh writ petition, making him a party and challenging the 17/125 also. But that's consequential. The short question is, can I file a compounding application after an adjudication order is passed? Now, according to me, this writ petition is perfectly maintainable. If your ladyship wants to hear the...
Tell me one thing.
Yes.
The show cause was issued on the 18th of November 22.
Yes.
And you filed your first compounding application on the 20th of January 23.
Yeah, within about 2 months.
Right. And it is returned nearly after a year.
Yeah, that they take a lot.
And is it permissible? Is there any time limit within which
There's
this
no time
compounding has to be done?
The time is 6 months after the complete information is furnished. They were raising objections, furnish this information.
All right. So correspondences were made in between.
Correspondence is there, and I furnished the information.
All right.
According to me, I furnished the information.
Right. And fresh compounding application, when did you file that?
I filed that on 10/5/24. 8/1/24, it's returned to me.
Why did you take so long from January till May in the meantime?
Because according to me, I can wait to see what the adjudication order is. If the adjudication...
All right. So you deliberately waited for the adjudication order to come?
I need not. I'm saying, my submission of the law is, I can wait till the adjudication order is passed. If the adjudication order is in my favor, I need not file a compounding application.
If that be so, then why did you file the compounding application
Because the
at the very
adjudication
first
order is
place?
against me. Adjudication order is 10 crore.
The P3 20th of January, first application you file, it is returned for filing fresh compounding application, which means till January 2024, there is no compounding application.
And there was a compounding application.
Returned to you.
Returned on 8/1/24.
That means there is nothing.
Correct.
Right.
So the compounding application is with RBI. The adjudication is by the Enforcement Directorate. The Enforcement Directorate, I'm not complaining. The Enforcement Director passed an order. He is within his jurisdiction to pass an order. Question is, after he passes an order, can I file a fresh application?
I have followed.
That's all. If I'm able to demonstrate that in 5 minutes, then
I get it.
I'm entitled.
What is your maintainability issue?
I will first take the prayer in the writ petition. I'll show 2-3 parts of the writ petition. It's at page 42.
Yes.
Prayer B.
Hmm.
Prayer is certiorari for washing of the impugned compounding order dated 11th September.
Hmm.
Correct? Your Lordship will kindly now take para 27 of the writ petition.
10th May there is
10th of September, 11th of
11th of September, yes.
11th September is under challenge. Now
But
your
then
Lordship,
28th of March there is already an adjudication order. All right, compound. Very well.
that is on 10th of September.
Yes, yes.
No, no, 11th of September.
11th September.
It's returned to me saying it's not maintained.
Rejection is challenged.
Yes, yes. Kindly come to para 27 of the writ petition now. This is the third round of litigation, in my understanding.
Yes.
Kindly first see para 25.
Hmm.
That compounding order is annexed at P9, dated 11th September. Now your Lordship kindly take para 27. Aggrieved by the impugned compounding order, petitioner preferred a writ petition being such and such before this honorable court on 13th December. My lord, the copy is not enclosed. I am not aware, because my lord will find at that stage petitioner did not include respondent number 3 and 4 as no cause of action has arisen against.
Three was included.
I am not a party. I don't know. I
Three
checked
was
from the
always
website. My lord, this writ petition is still pending
Still pending?
before your Lordship.
All right.
Yes, Your Lordship. I had pointed it out. It is appearing in the monthly
That
list.
compounding order, this writ petition challenging
Self-same cause of action to writ petition is not.
cannot be. This is my first point of mentality.
All right. Very well.
Can I answer that straight away?
Do you have any other point?
No.
Oh,
Not
this is
intelligibility, this only.
this is the only point.
Can I answer that straight away?
It's the content of the writ petition from their averment issue.
I get it. Madam, do you have any other objection?
Yes, Your Lordship. Although the writ application which is currently being heard out by Your Lordship is not in front of me, but as I'm told and instructed by the concerned officers of the Reserve Bank of India, that the prayer which has been sought for, first and foremost, they are identical, barring the only introduction of the demand notice, which they have now also challenged as a consequential relief to the prayers which are already there in the previous writ petition. But over and above that, if your Lordship would see, the prayer which has been sought for is for quashing of the order which has been passed on 11th of September 2024. Now, whatever has been stated to be the order, if your Lordship looks into the correspondence of 11th of September 2024, your Lordship will only find that it is not an order, it is only a mere communication where Reserve Bank of India has categorically stated that it is not possible to entertain because there is an embargo. If Reserve Bank does not have the jurisdiction to hear out the compounding application which has been filed and return it, then naturally the writ is not maintainable because under what has been submitted.
That is on merits.
That's on
We'll go
merits.
into it.
That's
But the
not maintainable.
maintainability.
My lord, this is yes, but so far as my contention before your Lordship is the order, whatever is stated to be the order, is not an order.
Very well. I take that.
That's on merits.
That the
Now
court will decide. Yes.
I'll answer my learned friends. The first question, the first issue is the first writ petition is also before your ladyship at number
1855.
185. Just a moment. Let me
Yes,
answer.
yes,
I didn't
yes.
interrupt you. 1855, the first writ petition, earlier writ petition is listed. Now kindly see paragraph 34 of this writ petition. So that is also before your ladyship. The earlier writ petition was filed. The demand had not come before listing. Once the demand came, I could have amended the writ petition or filed a fresh writ petition. And paragraph 34 at page 41. That while the petitioner had filed earlier WP
No,
against
it's
the impugned
it's only an undertaking to withdraw.
undertake to withdraw the earlier WP. So I'll withdraw that. Your Lordship may dismiss the earlier WP as withdrawn. The matter is over.
All right.
The subsequent development, therefore, it required me to file a fresh writ petition or an amended.
So this should have been done first, and then the second one ought to have been filed.
But I have undertaken to withdraw it. Your Lordship may, your ladyship may dismiss it
Yes,
now.
yes.
can take up both the writ petitions together and
I take it up on days list and I dismiss it as withdrawn.
he has withdrawn. Then my lord, my next point. The
Again, next point with
maintainability
regard
or
to
any other point?
maintainability or with something else.
Prayer C.
I inquired, do you have any other point or not?
On maintainability, he is entitled to argue, not on merits. After
Not on
I
merits.
But prayer C.
Yes.
Writ of prohibition. Prohibiting from the impugned demand notice 17/1/2025. Right. This is issued by the respondent number 4. This is issued by the respondent number 4.
Who is the respondent number 4?
Assistant Director. I've made him a party.
Now, this is in terms of, kindly take the list of date. This is in terms of the adjudication order dated 28/3. My learned senior friend submitted that this is under challenge before your lordship. The adjudication order is never under challenge, not even in this writ petition.
Right.
If that adjudication order is not under challenge, no appeal is pending. This prayer is not maintainable.
Was it under challenge in the earlier writ petition?
No.
There also it...
No, my lord. No.
I inquired whether 28th of March is under challenge or not.
Never under challenge.
No.
Challenging the adjudication itself. We are admitting to the
And there is an appellate authority also.
Now, when only
under the statute.
Recovery, they wake up.
The primary adjudication order is not under challenge.
I am not
Challenging the
obliged to challenge the adjudication order. All I'm saying is the adjudication order, I am filed a compounding after that. I'm not aggrieved by the adjudication order. After an adjudication order is made, if I'm right, I can file a compounding. That compounding has not been disposed of. Pending, that has been returned to me, and I will show that I can maintain a compounding application. Pending the writ petition, he is now issued a demand for 10 crore. I'm saying that demand for 10 crore is challenged in prayer E specifically. I don't have to challenge the adjudication order because I'm accepting that I have to pay compounding fee on that basis of that adjudication. Miller, if adjudication.
So the adjudication you accept?
Adjudication I accept, but I have a right to compound it.
I get it.
That's all I'm saying. Therefore, I don't have to challenge it. If I challenge the adjudication order.
The petitioner is walking on a very
I will answer
thin string.
But the demand
No.
only after his second.
That is on the merits, whether the prayer will be granted as a merit.
Yes, I get it.
I have to only show maintainability to the.
I understand.
I may be right or wrong.
That is different.
No,
but then the court was also thinking the adjudication order you accept.
Yes.
It is
Well,
only
if I don't accept the adjudication order, I cannot file a compounding. Please,
all right.
Your lordship will appreciate that.
I understand.
If I accept the adjudication order, I can file a compounding. If I dispute the adjudication order, I must file an appeal. The appeal to
appellate authority.
Appellate authority, and there is an appellate tribunal. If I want to compound it, I file
Very well,
compounding.
please. Show me the law where you rely upon.
The law is very simple.
Yes.
Now kindly have a compilation of where's my brief? A compilation of rules and regulations. Hand it over.
Yes.
It's been handed over.
Janao, এই মামলাটা
Now kindly see FEMA.
30.
FEMA is
My
the
lord,
first item.
may a copy of the same be also handed over to my advocate on record who is present in court?
FEMA is an act.
3003.
The compilation I'm entitled to, my lord, will kindly record.
What?
Yes.
It's an act, my lord. I don't have to give an act to the other side.
No,
My lord, when a compilation is being relied upon and the rules and regulations are being placed from that particular compilation and
compilation.
Yes, let a copy be also.
It's an
Yes,
act on the
I
rules.
have an act, but I would request my learned friend, nothing will turn on that. A copy may be also given to my
No, no,
advocate on
copy,
record.
if
That's
you request a copy, we'll give you. But you can't object
The
to that
Foreign
on
Exchange Management Act is placed.
Act and the rules alone.
Yes, yes, please.
Now kindly see the Act.
Yes.
Now kindly see Section 4.
FEMA 1999, Section 4.
Yes, at page 10 of
Page 10.
This is a convenience compilation.
Yes, yes.
I can show the Act itself.
Page 10.
Holding of foreign exchange, etc.
Yes.
Then kindly see Section 13.
13.
13, 1-3.
1-3.
At page 15.
Yes, the penalties.
Let me read it carefully. If any person contravenes any provision of this Act, or contravenes any rule, regulation, etc., etc., or contravenes any condition subject to which an authorization is issued by the Reserve Bank, he shall, upon adjudication, be liable to pay a penalty up to thrice the sum involved in such contravention, where such amount is quantifiable, or up to 2 lakh rupees where the amount is not quantifiable, and where such contravention is a continuing one, further penalty which may extend, etc., etc. If any person is found to, all that is not necessary, Milord. Only 13.1, I am liable to a penalty for a contravention. If any person contravenes any provision of this Act, he shall be liable to a penalty. Now kindly see Section 16. 15. 15. Any contravention under Section 13 may, on an application made by the person committing such contravention, be compounded. So somebody has to find a contravention under 13. He must hold that I am committed the contravention. Any contravention under Section 13 may, on an application made by the person committing such contravention, be compounded. So compounding can only be filed after a contravention is found.
All right.
That is the first point. Now this is made clear. And then 16 is adjudicating authority. That is a separate stream, enforcement directorate. We are now between me and the RBI. Now kindly see Section 17. Against an adjudication order under Section 16, an appeal to a special director is provided where the authority passing the adjudication order is under the special director, below the special director. And Section 19, where the adjudicating order is passed by the special director himself, the appeal is to the appellate tribunal. That doesn't arise here. I'm just completing it. Now kindly see, where is the hearing? Now kindly see the procedure. Hearing. Now the rules have been framed in 2000. That is serial number 3 of this compilation. It starts at page 67. And the rule 11 is a relevant rule at page 70. I'm only on compounding. I'm not on the adjudication order. Now kindly see rule 11. No contravention shall be compounded if an appeal is being filed under Section 17 or 19. That is, once an adjudication order takes place, if I go by the route of an appeal under Section 17 or 19, then I can't file a compound. But if I don't take the route of appeal, once I'm found to be committing a contravention, I can file a compound. That's the short point. Therefore, to return the compounding application on the ground, now kindly see the impugned order. The impugned order, the P9, 11/9/24 is at page 165 of the writ petition. It's been returned only on the ground after adjudication you cannot file a compounding. Now please see, it's a short order. Please refer to your application dated so and so, received by the Reserve Bank of India, seeking compounding. In this connection, since the adjudication order has already been passed by the adjudicating authority with respect to the contraventions applied for in your compounding application, the compounding application cannot be processed. Therefore, the captioned compounding application is being returned. No, the position taken by RBI is after adjudication, I cannot compound. I'm saying exactly the contrary. The law is after adjudication only I can file. But if I go by the route of appeal, I can't file. I accept that. If I filed an appeal under 17, I can't file. Or 19. This is here the special director passed an order. Therefore, kindly see the dates again. Adjudication order is passed on 28/3/24. I had two routes available to me. One is to file a compounding, one is to file an appeal. I have not filed an appeal under 17 or 19, and therefore I filed a fresh compounding application. This compounding application has been rejected and returned on the ground because adjudication order has been passed. I cannot entertain it. It is plainly wrong against the act and the rules. So let them file a counter and your lordship will hear it.
But then what is there to file a counter? This is a point of law
My
that
lord,
is required to be.
yes, it can be addressed here and now. It can be addressed here and now. I can make this point.
But they may have a defense.
No, they say they don't. They want to reply it here and
No,
now.
no, I would only, yes, I can answer the legal aspect of the matter here and now. But I would like to rely upon certain other contravention rules and master directions, which have yet not been placed by my learned senior friend. So unless and until those are already forming part of the compilation, I don't know, I would have to rely upon all those master directions because those are material. Yes, so those are material to be gone into. I can place from my office here, but it won't be before your lordship. So your lordship won't be able to simultaneously go through unless they are already forming part of the compilation. That was precisely my point. I wanted to have a look at the compilation, which has been placed before your lordship today.
No, there is nothing in the compilation apart from the act and the rules.
That's all.
So in the event
so there would be master directions. There are also master directions relating to the compounding rules because much has been said, but in one sentence, may I just wrap up here and now that so far as the rejection that has been said to have been issued by Reserve Bank of India on 11th of September 2024, yes, we admit that we said that already an order has been passed, but what is crucial and what was not mentioned before your lordship is under which provision that order was passed, because there is a bar, statutory bar, if an order is passed by the adjudicating authority under section 3 of the FEMA Act of 1999, then section 15 won't apply. Then Reserve Bank of India will not be the right authority to compound the offense as has been complained of in this petition. So that was precisely my point, which I was trying to yes, on merit I'm meeting the argument. My learned senior friend has already met.
The petition on merits, she is welcome to. Either she does it now orally or she files a reply.
Yes, on merits.
I have some wait here.
Yes, file affidavit. There is no scope for passing any interim order.
I don't My lord,
no interim order can be
no,
passed.
I'm asking for
Do you seek an interim order?
Please
Yes.
hear me for 1 minute.
Yes.
For interim order. And the interim order is pending. Your lordship is issuing notice on the writ petition.
Right.
Prima facie, I'm satisfying your lordship. Then the 10 crore can't be demanded from me now. If I pay the 10 crore, then what is the writ petition? The 10 crore demanded, that alone may be stayed.
Is any time period mentioned for payment?
It says
page.
It says 17/1/24 at page 166. Within 7 days.
Within 7 days, your lordship may stay this until the
right.
next hearing. That's all I'm asking. I'm not
Very-
asking.
Submission on this.
Yes,
I'm
what is
opposing
your
this
submission?
process.
Education.
Well,
Ah.
the moot submission is that compounding application, which has been, Malad has seen already the list of dates.
Yes.
This demand notice before your lordship is consequence to the adjudication order. That adjudication order was never under challenge, is not even under challenge. Now, the only contention is this, that even after the adjudication, if compounding application is maintained, which the RBI has wrongly rejected. On that ground, that adjudication order has been passed. So the writ petition, challenging that rejection by RBI. My lord is, I believe my lord is having the foreign exchange compounding proceeding rules 2000.
Yes.
My lord will kindly take that.
Listen, page 165 is under challenge. Page 165 of the writ petition.
Yes.
Only one line order.
Yes.
That since the after adjudication, compounding cannot be done.
That's enough.
But
Right.
he's not appearing for the
Right.
Then he.
This the court has to
My
adjudicate.
learned friend is appearing for the ED.
My lord,
He is not for the RBI.
My learned friend will kindly allow me to make my submissions. I know from whom I am at.
No, it's all right. But then the court has to adjudicate it, isn't it?
Kindly take that prima facie view is to be there.
Yes, which portion?
Kindly come to the foreign exchange compounding proceeding rules 2000.
Is the rules here?
Yeah, 67, page 6, serial number 3.
Which rule do you want to rely?
Kindly come to first. Rule 4.
Yes.
Power of Reserve Bank to compound contravention.
Yes.
My lord will kindly find if any person contravenes any provision of Foreign Exchange Management Act 1992, except clause A, section 3. So if
Yes, this is the one I was relying on.
then Reserve Bank has no authority. Now kindly come to 5. If any person contravenes provision of 3A, then it will be done by Enforcement Directorate.
Have you all done anything? You all have not done.
They haven't applied.
Well, they have to apply. They applied before RBI, who is not having a jurisdiction in case of a contravention of 3A. This is number 1. Now kindly take rule 6.
Yes.
Let me place the where any contravention is compounded before the adjudication of any contravention under section 16, no inquiry shall be done. So it means compounding will be before adjudication. Now kindly take 7. Where the compounding of any contravention is made after
One minute. 6 read once again.
Where any contravention is compounded before the adjudication of any contravention under section 16. Where under section 16 is adjudication. That means compounding will be made prior to adjudication.
Where it is made? Where?
Either under 4 or under 5. Either under 4 or under 5. Who has the jurisdiction? On application. It will be under application. Now kindly take 7. Where the compounding of any contravention is made after making of complaint under subsection 3 of section 16. What is this stage? The inquiry prior to adjudication. My lord, apart from these 2 provisions, your lordship will not find any other provision
for compounding.
So the stage of compounding is number 1, after issuance of show cause notice or prior to inquiry, but not after adjudication at any moment. So the letter of RBI, my lord will now kindly take the date list once again. The first compounding application was on 20th January 2023. What was the stage? The stage coming under section 7. Because at that, your lordship was asking what happened during this 1 year. During this 1 year, they were fighting against the show cause notice before this honorable court, which were turned down by the honorable single judge, which was turned down by the honorable division bench. Now, my lord, they kindly see the order was passed on 8th of January 2024.
Hmm.
Correct, my lord?
Hmm.
With the liberty, my lord will kindly find that at page 80. Kindly take page 80 of the writ petition. 80. The only intention is to stall the entire recovery. Nothing more. I will show it from their document. Page 80 is the email dated 8th January 2024.
Yes.
Correct? May I kindly come to para 3.
Yes.
In view of the above, the compounding application of Sri Sanjay Jhunjhunwala is being returned. Now the last sentence. The applicant at its option may approach ECBD with a fresh compounding application, duly ensuring that all the clarification information shot above is submitted along with the fresh application. So it was intimated to him in the month of January 2024. Right? Now thereafter what he did? He replied to the show cause notice, participated in the adjudication proceeding. He attended hearing for thrice. He made 3 written submissions where he contended that there is no contravention. Now, once he is saying, I want to compound, I can show from the correspondence, he has made the submission before RBI. Yes, there is contravention because the disclosure of guilt or acceptance of guilt is the primary requirement for compounding. They accepted it. Then when it is returned in January 2024, he came back and joined the adjudication proceeding, saying, challenging that there is no contravention. They have made 3 written submissions with judgment, circulars, everything. Whatever in their defense they have disclosed. Those have been dealt with in the adjudication order. Adjudication order passed. When? In March 2024. They waited. Thereafter, they made the fresh.
Show me the adjudication order once.
Yes, Mallory, starts from
84.
It starts from page 84. Mallory, their submissions, I can show your lordship. Page 100. It starts. Page 100, first para 3.1. In reply to show cause notice, Sanjay Jhunjhunwala letter dated 4/1, prayed for time to file reply by 21. 21, para 3.2 is his first reply. Now he starts here, A, B, C, D. It continues. Kindly come to page 102, clause F. Why I was showing the jurisdiction of RBI. E and F, they themselves says that there is allegation of contravention of 3A. If 3A is there, his application before RBI for compounding is itself without jurisdiction. Now kindly come the page 107. What he did at the top, 107, he requested the 107 top. He requested the adjudicating authority to wait till decisions comes
Which
by
portion?
RBI.
Which portion?
107, first top paragraph.
That he further requested.
Correct. Last sentence. Pending till the time a prudent decision is taken by RBI.
All right.
Thereafter, he joined the investigation. Para 3.4, 3.5, 3.6. He made a writ petition, this fact of writ petition. Then 3.7, division bench. 3.8, division bench. I can show you, lordship, the order of division bench, saying that adjudication authority has proceeded in absolutely in accordance with law. Then para 3.10, he appeared and made written submission dated 9/6. It is quoted. Then kindly come to next page 109, second personal hearing, para 3.15 and 3.16. He made written submission again on 28/6/2023. 3.15, 3.16. Then next one, page 110, para 3.18, made further submission dated 3/7/2023. This is the third submission. Then, considering all this, discussion and finding of the adjudication order starts from 111, which continued up to page 139. This order is passed in March 2024. But even after that, he waited up to May. But under the law, this order is appealable within a period of 3 months. He did not prefer any appeal. he made the fresh compounding application when this option was given to him in January. He did not obtain it. He participated in the adjudication. Today he is saying that I may have filed, but I waited for the adjudication if it is in my favor. But the law does not permit after adjudication. I've showed Rule 6 and Rule 7. Except Rule 6 and 7, there are no provision for the compounding. And 3A is staring at their face that the application of compounding has to be before the ED in terms of Rule 5. Their application before RBI is not maintainable under Rule 4. So now today, even after that, when I issued the demand notice, March order, I issued the demand notice in January.
What is 3A? Please tell me once.
3A. My lord, kindly come to 3A. 3A has been made separate because 3A is till save as otherwise provided in this Act, rules or regulations made thereunder, or with the general or special permission of the Reserve Bank, no person shall deal in or transfer any foreign exchange or foreign security to any person not being an authorized person. So without the permission of Reserve Bank, if any person deals in or transfers any foreign exchange or foreign security to any person, that is a contravention of 3A. Now, if there is a contravention of 3A alleged, the compounding will be under Rule 5, not under Rule 4. RBI cannot deal in Rule 3A. And moreover, the compounding is always prior to adjudication, 2 stages. One prior to completion of 16, one prior to 16.3. Kindly take 16. Section 16.
Since we appear to be arguing the full writ petition, may I
Section 16, subsection 3.
There is points of law has been raised. There is no factual thing that is to be brought on record.
If you are arguing the writ petition, I'm ready to argue the writ petition.
Yes, it is because.
They want
but then
time
the
to file a reply.
RBI Learned Counsel doesn't have the brief today.
I'm very happy to argue.
Yes. He is not entitled to any interim order because of the conduct and the facts.
I'll
Since the inception of the proceeding.
He has made the point.
Even today, pending a writ petition, he has preferred this writ petition and undertaken to withdraw. Whereas my prayer would be that this writ petition today should have been adjourned unless the earlier writ petition is withdrawn. The wholly barred.
Can I deal with that point?
Now I'm praying that no interim order be passed.
Yeah, you made sense.
The copy of the order.
Since he is opposing the interim order, which I am praying for, may I deal with that, my lady?
Thing is, I am thinking of disposing of the writ petition.
I am ready, but if
yes.
they are asking for time, I am ready to stay.
Right.
It'll help me to come to Calcutta High Court once and argue the entire writ petition. I'm ready. And I'll take my judgment.
My lord may ask for a report from respondent number 1 if they are willing to do so.
No. Why should my lord? We are not in a position to give any report.
It's a pure question.
The law is very clear. It's
so what is the use of a report?
Question of law.
But the council doesn't have a copy of the writ petition today. She requires
a copy. The earlier writ petition may be withdrawn.
Today this order can be passed.
Already said that.
And this matter may be fixed on some other date for it to be.
It can be heard out without granting any opportunity for filing any affidavit.
No objection to whatever course my lady may follow. If they want time, your lordship may grant them time. If they are ready to argue, I'll be very happy to argue it today. But since you granting time, fix another date. But I'm saying, pending the writ petition, the interim order for 10 crore, I'll make out a case for that. He's opposing it.
No, if it is taken up, say, very shortly.
No,
day after tomorrow.
As long as they.
Day after tomorrow, it can be so short.
Day after tomorrow, I'm in Delhi.
You can stay back. Enjoy the city.
I
Delhi
can't-
is far more polluted than Calcutta is.
Well, on earlier
I
occasions, I had the
can't-
opportunity to appear before my learned senior. He used to appear virtually also because he's too busy in Delhi also.
Right.
I can't stay
So
back for 3 days.
virtual appearance is permissible. There is no difficulty.
Virtual appearance is something which my client must decide whether he wants me to appear physically or.
Very well. So if you stay back,
I don't know how long they want to file a counter.
they will not file.
No, she said, I heard.
No. What I
Calcutta
said
is
was
relying upon.
basically, yes,
She
there are
does not
certain
want to
master
file a reply,
direction
then
which
we'll
I'll.
argue today.
Yeah,
I'm arguing
today she doesn't have a copy of the writ petition. Thing is only this. Otherwise,
Yes.
if you can stay
Let the
back
matter be made returnable tomorrow. I will come
I
and
can't
make the
stay back,
submission.
Lord. So that's not possible.
tomorrow also, it's
No,
not
no,
possible.
I've got other matters committed. The earliest I can come back is the 5th of February, next week.
Very well, my lord. 5th of February, if your lordship is otherwise not inconvenienced, can keep the matter.
5th of February, but no interim order.
No. Unless they
Obliged.
say they will not take coercive action.
Well, we have not taken any coercive
They
action
will not
till date.
take.
Since March, we have not taken any coercive
I
step.
can't.
March
I can't speak.
2024.
So we have not done anything.
Sorry.
Only a notice has been issued. Now they have wake up.
I'm sorry.
All
I
right.
cannot
So
speak.
he can wait up to 5th of February.
I cannot. I
Please
have
come.
to speak softly. I cannot speak as loudly as my learned friend. I have no complaints.
That's the
I have no
Sometimes
complaints.
this softness becomes quite loud.
more powerful.
So it's
point
no
is-
reason to
And my
raise your
ideas
voice.
to the
Just
decades.
allow me to make a statement. Please note, maybe not in writing, that he has made a statement that
yes.
between now and February 5, no coercive action will be taken.
Well, instead of 5, can it be on 4th?
No,
It's a holiday.
Oh, 4th is holiday. I don't know how other courts have given me date.
Why is the 4th holiday?
One matter is there already on 4th. Then, my lord, kindly on 6th.
No, I can't come.
My
on
lord, 6th, I have some personal difficulty.
Come on,
Not
Divya.
6th, any other
Come
day
on,
apart
I will
from
be there.
6th.
আচ্ছা
I will adjust in other matters.
এটা হচ্ছে এটা 3003024 আইটেম নাম্বারটা চেক করে নেবেন
এটা লাগবে না।
in the combined list. হ্যাঁ
Monthly list 1855.
1855.
Yes, your lordship.
Please dismiss it as withdrawn.
আচ্ছা এটার অর্ডার হচ্ছে the learned senior counsel representing the petitioner submits that since a fresh writ petition has been filed upon subsequent facts accordingly
1855. Serial
the instant writ petition may be dismissed as withdrawn.
Your ladyship may kindly add, since a fresh writ petition has been filed, impleading R3 and R4.
All right. The
R3 and R4.
orders impugned in the instant writ petition are also impugned in the later writ petition that has been filed, being WPA 2065 of 2025. Stuff. This becomes dismissed as withdrawn. ঠিক আছে? Record everybody's appearance. And next one, 2065, today's list. The order dated 11th September 2024, passed by the Reserve Bank of India by returning the application for compounding filed by the petitioner on the ground that the adjudication order has already been passed by the adjudicating authority is impugned herein. Stop.
That's the only question your ladyship has to decide. Can I file a compounding after the adjudication order?
The relying on the no, not relying, as a consequence of the adjudicating order, comma, a demand notice dated 17th of January 2025 has been issued directing the petitioner to pay a sum of rupees, to pay penalty of sum of rupees 10 crore.
Or to produce the appeal. Kindly see the last entry.
I'm not filing an appeal.
So I've given him both the options.
He can't compel me to file an appeal. I'm not filing an appeal.
Or to produce the copy of the appellate authority dispensing with depositing the imposed penalty. Stop paragraph. Specific submission is that the application for compounding can be made even after the adjudicating order is passed.
That's only
Stop paragraph. The learned counsels representing the Enforcement Directorate and the Reserve Bank of India submits that the application for compounding, asserts that the application for compounding cannot be made after the adjudication order has been passed. Stop paragraph. The only point of law that is to be adjudicated in the instant writ petition is whether an application for compounding can be made after the adjudication order has been passed by the adjudicating authority. Stop paragraph. To allow all the parties to come prepared, list on 5th of February 2025. Stop.
No,
it is expected that
I will finish
further
15 minutes. I don't know.
coercive steps will not be taken by the Enforcement Directorate
Let's see.
in terms of the demand notice dated 17th January 2025 till 14th of February 2025 or until further order, whichever is earlier.
Well, my learned friend, because he's familiar with this court, he says it must be placed higher up so that it will reach.
I'll see that.
I'll only take 20 minutes. That's all. I mean, less, in fact. In fact, I've argued it, but I'll refresh your ladyship.
Yes.
20 minutes, and then your lordship
Let me see.
may take
Place
it up.
it at the top of the list so that it can be taken up. No. It's already appearing as urgent motion. It will be there in the urgent motion bundle so that it can.
No.
So urgent motions are taken up on regular basis.
My lord has directed me not to take coercive steps till 14th of February.
What is that?
All 7 ones.
Obliged.
Grateful, Your Lordship.
I'm told affidavit of service has to be
Yes.
filed.
Service is taken on record.
I beg to appear on behalf of the Union of India in item number 7, my lord.
Lord, I appear for the petitioners, your ladyship. This was filed upon obtaining leave of your ladyship, my lord. This also relates to exotic birds, which I have, my lord, under my possession, which I was supposed to declare under the new rules. I have made the declarations. Now I have received emails. It is just as same as the other case I had placed before your ladyship. I have received an email which starts from page 81. Oh, I'm sorry, your ladyship. It is only at page 81, one singular email.
Only at page 81, my lord.
So, which is the last annexure. Your application under the Living Animal Species Rules 2024 has been rejected after hearing on Parivesh portal. So there is no order of rejection which has been communicated to me, and this is
What was the last order passed by the court?
Yes. May I hand over a copy? একটা দাদাকে দিয়ে দাও। একটাই আছে, আমার কাছেও নেই।
Are you ready with instructions?
No. If your lordship has already applied your bind mirror, I must not stand in the way. Allow me to come.
The reason of rejection may be different, may be same.
Might be different.
There has to be a separate order of.
Yes, order of rejection. Only updating or uploading it in the portal that it is rejected will not be proper.
Like as your lordship, yes, my lord.
Because my lord, in the clause
Is the
rule
29th
10, my
this
lord,
matter
there is
there?
a
Yes, but the my
Position is such.
position is 97 in your ladyship's list today.
What can be done? You see, every day so many matters are coming and with
I did not
instructions.
trouble
it
your
makes
ladyship in the
return
morning
to-
with mentioning.
I cannot
Only thing is,
help.
if I may suggest one thing, subject to your ladyship's pleasure, there are 6 more matters in the list, which has also been mentioned before your ladyship on the last occasion. They are also there at the trailing end, and these birds matter, if I apprehend correctly, there are many more to come to your ladyship's. So if your ladyship's, this is just a suggestion for your consideration. If your ladyship is pleased to make a separate head for this will be probably
Separate head?
probably
May-
save time of the court.
may,
1 minute.
may I-
97 you say. The other one is 97.
97.
Mr. Galib was there.
Yes.
And who was
May
supposed
I-
to give instructions? The central government. Yes. And central government?
The learned DSG was appearing.
In this matter, who is appearing?
Admit
Yes.
one thing,
Yes.
my lord. My lord, I am
Mr.
appearing
Jha,
on
are
behalf
you
of the
ready
Union
with
of India.
instructions?
Para 37, my lord. My lord, I am not ready with the instruction, but my lord, I would like to place one submission, my lord, before your lordship, my lord.
Yes,
My
please.
lord, if your lordship, my lord, in rule 10, my lord, that is at page,
Oh,
my lord,
appeal provision.
there is an appeal provision of appeal, my lord, that they have specified in page number 37, my lord, that in the order of rejection, they can prefer an appeal before the central
Show
government, my
me
lord.
the
Now,
order of
this order
rejection,
itself,
please.
there is no reason.
No, you show me the order. There must be a formal order. It's
My
only
lord, that page 81, my lord, I am. Yes, my lord. I follow, my lord, what
rejection.
is falling from your lordship, my lord. If my lord, it has to be a descriptive one. They should have given the this reason why they are, my lord, rejecting it. It has to be there, my lord, for the reason so that they can appeal. My
Another thing is that order
what
is to
I
be
was
passed by the
submitting,
state authorities,
that
state
since there is a
officers.
provision of the department, the
communication by the
department
central
will give
government
them a
officers.
reasoned order, my lord, and give them a reasoned order so that they can prefer an appeal before that thing.
Produce the
If
copy of the order.
my lord, this is
Produce the copy of the order of
my
rejection.
lord,
And
my
if
lord,
the court sees that there
my
is
lord,
any, then they will be relegated to the appellate forum. Otherwise, it will be sent back to the
my lord,
adjudicating authority.
adjudicating on the authority, my lord, my lord.
Only thing is
My lord will fix it up on any day with other matters. We'll come up with the order of rejection, my lord.
since your lordship is restraining us, my lord will kindly give a short date.
Yes. The other one also very short date was given. 22nd it
Yes.
was taken up and 29th it was returnable, and it is
Yes.
it is in the list but cannot be taken up. Central government in the other matter, Mr.
Mr. Dheeraj Trivedi was appearing.
In this matter, I can understand. Is Mr. Trivedi there? Miss Pandey?
And he was being
Well,
assisted by Ms. Pandey.
I'll be able to communicate him, my lord. If your lordship so desires, my lord, I'll communicate him if the matter is
So had the
fixed
reason
up
been
with
brought
regard to other
today,
matters.
had the reason been brought
My
today,
lord, I could, I appreciate, but my
it's
lord,
already past 1:30. I'll take this at 2. Intimate Mr. Trivedi or Miss Pandey, whoever. If the reason is there, then I can understand what
Yes, very well,
exactly
very
it
well.
is, and we can proceed.
Let us come back at 2 then.
Yes, at
7
2.
and 9. Yes, I'll come back.
97 will also be there. Just
Yes.
intimate.
my lord,
97 এর ফাইলটা বার করে রাখবেন।
extremely grateful, my lord.
Lord, I have taken instruction, may I, Lord? Will kindly come to page 81. So this is a rejection. This authority considers the list of documents as, my lord, uploaded by the state authorities. Lord, here, my lord, in the present case, we could not upload certain documents because we, in spite of calling upon the petitioners, they did not produce such documents to us. Consequently, my lord, we did not upload. One of such vital document is the source of the bird, which were called upon by state authorities. The petitioner allegedly could not produce the source document. What has contributed to this, my lord, might have, my lord, all the people who are in possession of birds were supposed to, my lord, give their declaration in the Porivesh 1 portal by a date. Date was 15th March 2021. So anyone who has not produced this declaration, the department is assuming that the source is illegal because they did not give their declaration within the time frame to this Porivesh 1 portal. Now, my lord, since this, my lord will kindly take this document. This is the document of the present proceedings. This is one of the forms. 1 minute, my lord. This is one annexure which I have uploaded to the central government in the central government's portal. I will see the number of birds, name mentioned, everything mentioned, my lord, date of position and all. My lord will kindly turn the page. Serial number 5, my lord will find.
The petitioner, Oshim Ardo, isn't it?
He is in possession of all these birds.
All these birds.
All these birds, my lord.
All right. Yes.
My lord, will kindly come straight away to the, my lord, paragraph clause 13.
Any other information?
Any other information. My lord, will kindly see on the right hand, voluntary declaration regarding such and such, my lord, proposal number such, and found not approved. So possibly it is not approved because they did not give the declaration before the due date. So it is presumed.
But then till you intimate the petitioner that these are
I will.
deficiencies, how
I'll indicate their predicament also. My lord will kindly have that trust on me, my lord.
Yes.
I'll also, my lord. So, my lord, there is a backup file. But, my lord, fact remains, today there is a rejection, which is at page 81. And I do not have any reasoned order. It is not there. At least not in my case, my lord. I cannot submit, go to other matters, my lord. In my case, it is not there. So, Lord, subject to my lord's kind approval, my lord, we may be directed to consider their case afresh and communicate to them as well as, my lord, we'll reload or re-upload to the central government portal. In such, my lord, let them, what I'm on, my lord, this subject to, again, my lord's kind approval, one possible solution to redress the entire issue might be that the page 81 needs to be set aside. My lord will kindly direct them to make fresh application. Lord, we'll consider such application and pass a reasoned order within whatever time frame your lordship directs. And, my lord, we will upload the corresponding documents to the central government portal for their consideration.
But what will be the application for?
Lord, applicant. Lord, this rejection, this form 2. না, কি application-টা করবে ওরা?
Your application under
Because
the
they
living
will,
species
form
has
2 is
been
the
rejected.
application, my lord. Form 2 is the application. This is an online application. Today, my lord, this has observations that some of the required documents were not approved.
If till you intimate the petitioner the deficiencies that these are the
Lord,
documents that the petitioners are required to upload or forward it to you,
Lord, I
how
am
will
told,
the
Lord, I am
petitioners
told
know?
the petitioners were time and again called upon to produce the source documents.
Show at least one communication.
How? It will be there, my lord. I am told, my lord, in the file. But, my lord, I was going one step ahead to address the issue as on now. As on now, my lord, we have already submitted our
This
documents.
can be rejected being a non-speaking and a cryptic order.
My lord.
And then the authority has to reconsider the matter all over again.
My lord. That can be done, my lord. My lord, once this application is my lord, uploaded to the central government's portal, my
Wait,
lord.
yes. Now tell me one thing. Did you make any application before the authority?
Yes.
What is the application? Where is it?
The application is contemplated under Rule 3 of 2024 rules, and your ladyship will find the applications at page 61 of the writ petition.
61.
This is the form 2, my lord.
61 is form 1.
Yes.
Form 1.
Where is form 2?
Form 1 is the application, my lord. Form 1 is the application.
Yes.
Form 2 is the order of the authorities.
Report of the Deputy Conservator of Forests. So you want the petitioner to upload or reload 61 again?
My lord.
It won't serve the purpose.
Yes. It is already before them.
Your Lordship, I'm appearing for the Union of India.
Right.
It will serve the purpose if there was any shortfall on their part to submit any document. As it was mandatory, a declaration had to be given. If they had failed,
you say that he has failed. Give the reasons that this is the reason for rejection. They will immediately give the proper.
Then there is an appeal.
It comes later on, madam. Till you intimate the petitioner, these are the shortcomings, these are the requirements, these documents are wanting. How will the petitioner get to know?
Your Lordship, it is the state government which communicates to them by
This
email
is what
and
he
other.
is saying, that as the petitioner did not forward it to the state couldn't forward it to you. This I can understand. But the state has to say
What I
what the
understand is,
documents.
there is a technical test. Their test is a more technical test. If they are not satisfied with document 1, 2, 3, 4, 5, they will reject. So theirs is a technical test. Mine is a more
subjective,
reasonable test. I have to carry on that exercise. So, my lord, but my lord will, in my lord's order, kindly take note of this one issue, that the department says they were not able to produce the source document. So that
communicate the petitioner the documents which may be required.
Setting aside the order,
yes,
my lord will kindly take. Why I say this, my lord. So petitioner today are aware of this. They cannot take.
Aware of what?
Aware of that fact that they have to produce the source document.
Is this the only document that you require, or there are other documents also?
This is more fully, this is the...
No, it may be some other document also. You intimate that these are the documents required, forward. We'll, you all can process.
Your Lordship, the central government have started a counting as like a Janaganana of all the animals, including domestic and wild animals, whereby already this procedure is taking place from 2021. So as on the cutoff date, they were required to submit a declaration. Several of them have failed, as a result of which, when search and seizure were conducted, they were found in possession of illegal birds, and prosecutions was taken place. And there are several people under who are already being prosecuted. They are also applying. So their case are deemed to be rejected as they had not followed
No, no.
It is just like
That is in the petition we have followed.
Seems that there are two types of
why I insisted that I found out from my officers why I insisted on a reapplication. I will kindly see this is not any hard copy. It comes from the portal. Now, this form has been registered. It has come to the state authorities. State authorities has already uploaded this form to the center authorities, rejected. The file is already rejected. Unless a new file is created, new application is made, it will not come to me for consideration.
Server will not take it up.
There is no provision for reapplication in the act.
So by court's order.
There is
In fact, there was a scheme which. But there was a.
Who are you for?
But I also appear for some of the petitioners. There are several matters which are.
All right.
But since your lordship is taking a holistic view of all the matters, this may
Not holistic view of all the matters, only
this
one.
disposed of, not
and the other one.
today we have heard of tigers being not banded.
Yes.
But I don't know whose brainchild is this, but the tiger, not tigers, elephants, they will be killed in the
Whatever.
process.
Now.
In 2020, there was a scheme floated by the Union of India. What was the scheme? If within a period of 6 months you apply for registration, then you don't have to disclose the source. So there was a time stipulation whereafter a physical inquiry and verification of the aviaries were carried out. But what was the scope of this inquiry? What is the health of the birds? What is the atmosphere in which they have been kept? What is the treatment they can be given? What is the nearest veterinarian? And what is the protein diet or not the diet which can be offered to them? So this was the general scope of the inquiry. In this process, birds had been registered. Now the offspring is not being registered because of not uploading. That's the consequence of not re-uploading the. I don't have a difficulty in uploading the application form once again, because I enjoy the exemption in so far as that 2020 notification is concerned. So if the center or the state today says that you have to once again declare the source, then they reopen a closed issue.
Lordship, the new.
You see, there is a.
The advisory is at page 30 of the petition before your lady.
Advisory. Please take any one of the
page 30.
Registration করতে হবে. So they are a new creature, new birth certificate.
That's true. Otherwise, what is the use of this?
Just after the background, your lordship will be pleased to find there is capital Roman 1, developing an inventory of exotic live species in India through voluntary disclosure scheme. The phrases exotic live species used in the advisory shall be construed to mean only the animals named under appendices 1, 2 and 3 of the Convention of International Trade in Endangered Species of Wild Fauna and Flora for the purposes of this advisory, and does not include species from the schedules of the Wildlife Protection Act 1972. It is stated through this advisory that the declarer would not be required to produce any documentation in relation to the exotic live species if the same has been declared within 6 months from the date of issue of the advisory. For any declaration made after 6 months of the date of issue of this advisory, the declarer should be required to comply with the documentation requirement under the extant laws and regulations. So this was, say, a one-time leverage, or say some sort of a amnesty,
as has been held by Supreme Court also.
What is the date of this?
This was of 2020.
June 2020, and this span of 6 months was later extended by another 6 months, and the last date was on March 2021.
All right.
15th March 2021
Yes.
was the deadline.
End date.
Our applications are also in annexed to the petition, which we were supposed to do, and which they are saying that we
But
might
there
not
is
have done.
annexure 1 is a form of declaration which is annexed to that scheme. Please come to, the pages won't tally since you are.
Yes, yes, I have got
There is
one.
a form of declaration in annexure 1 to the scheme.
34.
Name of the owner, stockholder, address of the owner, phone number, email ID, name of the species, common name, scientific name, photo, numbers, juvenile or adult, male or female, country or state of origin, address of the facility where exotic live species to be kept or transferred, date of import, transfer if applicable, DGFT license number for import, reference number of original stock number, transfer if applicable, letter number of NOC issued by the CWSOL, then remarks. Please see that is not applicable because that is for death, transfer or acquisition, but similar things are there. Disclosure is there. Now, on being satisfied with the disclosure made,
they carried out physical inspection of each of the aviaries.
Yes.
And that is why a hearing was given for the purpose of carrying forward with this declaration. On being satisfied, registration of the birds was given, was made. Today, if a offspring comes into the light, then it has to be registered as a birth,
There's a
not as
provision.
an acquisition. Not it makes three types of
Yes, yes.
registration. One is
Right.
birth, death, acquisition.
Birth is under 2.
So acquisition having been held to be valid through an amnesty scheme, I can only get it registered for the purpose of birth.
So you mean to say that the first acquisition has already been registered?
For those who had applied within 6 months.
Yes.
1 year, sir.
Or extended by another 6 months.
Within the specified
Yes.
stipulated time period, right? Where is this registration? This has been rejected.
Yes, no, 39. My lord,
What has been-
she will kindly come to page 39 once. So there is an advisory. Under that, one portal is opened called Parivesh 1.0 portal. Thereafter, an amendment is brought in the Wildlife Protection Act, amendment of 2022. Section 49M is inserted. But they require the fresh registration, etc. But those were not put into effect till 2024, when the rules of 2024 were put in place. So by putting in place rule 2024, another portal was opened by closing Parivesh 1 portal. Another portal is Parivesh 2.0, which is commonly known.
No, without going to that stage.
Yes.
First, it has been submitted that
The advisory.
Yes, 1 year
39.
time, you have already registered.
Page 39.
You have applied for registration.
Yes, I have applied for registration. So what is the consequence? They are supposed to carry, my application will be there.
Yes.
They will be required to carry out their portion of the work and then give me a
Registration
certificate saying-
number.
yes, saying that yes, registered.
Your bird is registered.
Yes, but that your lady.
That has been rejected.
Yes,
Rejected.
It has been
So it has
No,
at
no, that has not
stage.
been rejected.
Understand?
That is
registered.
That has kept pending in my case. And the consequence
Registration
of
for declaration of not. I just give an example. That was registration for declaration of stock of exotic live species.
Hmm.
Date of approval, status proposal is approved. The proposal comes after physical inspection.
only to guide your ladyship, will kindly comes to page 39.
39, I can
39
see.
at the bottom, it says my application, it says proposal is pending before Chief Wildlife Warden. In Mr. Mojumdar's case, it says approved.
Yours, since I have this paper, yours has not been approved. So yours has
Pending.
not been registered. It has been rejected. Where is the pendency?
Rejected? No. Let me again place it before you. Under Parivesh 1, we make applications.
Yes.
Those are to be registered. Those I have shown that they are kept pending. I'll come to the effect of pendency later. But after coming into force of the 2022 amendment and 2024 rules,
Yes.
I again need to re-register.
All right.
That application was made and that was rejected.
So
The first remains pending.
What happens to the first one?
That remains pending.
The time-bound procedure.
What
But
is-
to note the effect, if I may say this, that these issues were considered by the Honorable Rajasthan High Court Division Bench in the similar issues. And then it has been held that once the application is made from the applicant and it has been kept pending without rejection, then it will be a deemed approval.
Provided the law provides. Tell me one thing. What happened to this application which was made under the Parivesh 1 portal?
Your Lordship, with that, we do not have.
No, but as for example, I show one of the cases in the writ.
Yes, where you say registration has been allowed.
If it is, my lord,
Made in
if
the
it
previous
is
portal.
my lord,
Applied. It's
within the
approved.
time, it is deemed approved.
It's deemed approval, Parivesh 1.
Here, my lord, Manar will kindly not be oblivious of the fact that we are not dealing with one single bird. There are
Several. Yes.
So, my lord, one might be approved, second might be rejected.
But then each and every approval has to come separately.
Lord,
Or is it comes as
Each bird separately.
my lord, it is a
One.
deemed approval.
one for one, obviously.
If it is pending
Right.
consideration in the Parivesh 1 portal, it is a deemed approval.
That means it's approved.
Approved.
And it
He-
is only
my
then
lord,
that
my
Parivesh 2
learned
comes
friend
in.
is not in a position to show pending application in case of all the birds. That is the problem.
No.
That is the reason that I am going for the source. But if all the birds are
Well, if we take one by one, then here this is the bird number mentioned or some bird which is application number such and such.
see the birds number are mentioned.
250630.
Page 39.
39250.
Yes, 39 it continues. There are other proposals also. Further at page 41 starts. Another starts at page 43. The last one starts at page 44. Now, in the meantime, there were total of 89 applications made, out of which 85 are birds. I am concerned now with only birds. Under Parivesh 1, 85 were birds. They are all kept pending. Your ladyship will not see a single rejection. Whereas I make the applications of some of the birds of these 89 birds in Parivesh 2.0, they are rejected. I don't know the reason for that. So it is not a case that where I have not declared all the birds. I declare a greater number in one.
Initially, Parivesh 1, you have declared all. Now, Parivesh 2 is rejected.
Yes, lesser number of birds I have declared over here rejected.
Your Lordship, there are several birds. If your Lordship is looking at individual case and the order comes, which would be applicable to all, it will be difficult.
Yes.
Here, what is the purpose? The purpose is for safety and protection of wildlife. These are wild birds. Even emu.
Just let them know. Since they do not know the reason for rejection, let them know. Because each bird may have a different ground for rejection.
Yes.
If it is the source, let them know that this is you have not disclosed the source document. You cannot do it all in one. Right? One size fits all cannot apply over here.
Your Lordship.
Because birds are different.
Rule 4 provides in case of an offspring born out of any of the bird which were in Pravesh Portal 1, they have to again register.
I have no case of offspring.
We are not dealing
with yes, right. Since an offspring was mentioned, that is the reason she is answering. But particularly in this case, there is no offspring.
Probably that can be registered as a bird. Not as a
giving liberty to the petitioners to file afresh in Pravesh Portal 2, and a reasoned order will be given to them.
What is the trouble if they reapply? We are taking this plea that they cannot reapply in accordance with law, but it is not in fact a reapplication. My lord is setting aside the impugned order, and my lord, since the process required, what will come to us, my lord will kindly see. The uploaded documents comes to us. Now it is not before us. It has already gone to the central and rejected. So it has to be reapplied according to my offices. So there is a technical, that is the technicality of
what the petitioners are apprehending is that there was a time frame within which the application was to be filed.
If they have applied, they have applied, then this point we cannot take.
Right.
There is no question of if time frame was applying before Parivesh 1.
Parivesh 2, there is no time frame.
There is no time frame. We are seeking, I am praying for your lordship for their application under Parivesh 2 only.
May I?
If they can substantiate, that this X number of birds were applied before the Parivesh 1.
Where to substantiate?
Printouts.
Documents. Uploading
in the form, it will be
This is wrong. There are time frames. May I take your ladyship through subject?
Parivesh 2 also, is there a time frame?
May I take your ladyship through the rules? Everything will be clear. Page 55, your ladyship may come to page 55.
Page 55.
Page 55, which is the portion of the 2024 rules.
Yes.
Kindly comes to 3.
Application for registration.
Every person who is in possession of any animal species shall report the details thereof and make an application for registration electronically to the management authority or the authorized officer.
6 months from the date of commencement of this.
So there is a time frame from the day.
Thereafter, within 30 days of the possession of such animals.
Right.
So your submission.
Number 1 and number 2, while we are at it, your ladyship may kindly come to sub-rule 5 of rule 3. CWLW is the authorized officer, and kindly comes to rule 5 of sub-rule 3. I am sorry, sub-rule 5 of rule 3. The applications received as per sub-rule 1 shall, if found complete in all respects, be forwarded by the management authority or the authorized officer within a period of 15 days to the deputy conservator of forest having jurisdiction over the area which the facility is located. Thereafter, 6, the deputy conservator of forest shall, on receipt of application under sub-rule 1, upon an inquiry and physical verification of the facility, submit a report. So, unless the authority is satisfied that the application is complete, there is no question of forwarding. In my case, there is a forwarding, and thereafter a physical verification. I have annexed documents.
Please come. Please come.
Similar to us also. তোমাদেরটা তো better, তোমাদেরটা approve.
The matter relates to the living animal species, bracket open, reporting and registration.
Lordship, item number 97, Lordship will hear.
Rules, 2024. Submitted by the petitioner in Parivesh portal. Stop. The application has been rejected.
Your Ladyship, may I just interject once?
There are
This is not
several.
a rejection.
Page 81.
This is an information of rejection because the rejecting authority is CLW, which is a state officer. This is by the central officer. This cannot be taken to be the
Acha, ঠিক
order.
আছে, please come.
And the order needs to be in under tandem of rule 9.
The petitioner has been intimated about the rejection of the said order, said application. হ্যাঁ, rejected টা কেটে দিন। ঠিক আছে? The reason or the grounds for rejection of the application has not been communicated to the petitioner. Stop. Without the grounds or reasons being communicated, comma, the petitioner will not be in a position to apply for to appeal against the order of rejection. Stop. Paragraph. The communication has been made by the monitoring cell, bracket open, environment, comma, forests and wildlife clearances, bracket close, Ministry of Environment, comma, Forest and Climate Change, Government of India. Stop. Next. The
Kindly,
yes.
for once, I will take into consideration column 14 of the document I have handed up to you.
Yes.
Form 2 is uploaded, so they know this. They are aware of this form 2.
No.
It's not uploaded.
No. We can.
You upload it directly to the central government's portal. The petitioners don't get to know.
But that is the procedure, my lord.
Then they should also be forwarded a copy.
And the order needs to be in the form prescribed under Rule 9, not some noting. দাদা এটা কার সাইন করা নিচে হবে না তো তাহলে তো it is not a order. Deputy conservator is not the person who is authorized.
Recommendation.
Recommendation. It is not a
recommendation.
Order then is order to
Order to central
According to the notification dated 28th February 2024 by the Ministry of Environment, comma, Forest and Climate Change, comma, Government of India, the management authority or the authorized officer has the power to reject an application if not found complete in all respects. And the order of the management authority or the authorized officer is to be in writing and to be signed and dated by him. Stop. Paragraph. In the instant case, no order of the management authority or the authorized officer has been communicated to the petitioner. Stop. Na comma din. Only the intimation of rejection has been uploaded in the Parivesh portal. Stop. For the petitioner to take up the issue, the petitioner requires the grounds for rejection so that steps may be taken by him to rectify the defects or to fulfill the shortcomings. Step next. In view of the above, the instant writ petition is disposed of by directing the management authority is not a party.
Yes, because
Then-
the 8 would be the authorized officer. Authorized officer.
Achha. Paragraph then it has been submitted that the chief wildlife warden is the authorized officer. To take a decision in the matter. Stop.
Forward the documents to the central government.
But that has already been forwarded.
The decision will be taken by respondent number 4. The communication of rejection.
Communication made by 4.
No, either or.
Communication is 4, all right, but communication is not the thing. Thing is the rejection. Rejection at what stage? Is it at the state government?
No, Your Lordship has not taken up exactly the right point, my Lord, I'll say, because I will furnish the details to the
central government.
This has to be considered. Now, if the central government is accepting my recommendation and rejecting,
then an order has to be
on them.
Uh,
I have not exercised my
subject to correction.
Exercise the form once again, Your Lordship. It will save them the hassle.
It cannot be. For you, it may be a hassle, but for them, it will be difficult. You have to calibrate your portal to that extent that it can do it. You have to update.
Software as of now does not permit that.
Then do it in the hardware. If the software doesn't provide, may let hard copies be provided. What can be done?
Signed copy, so it has to be hard copy.
Yes, signed hard copy. And subject to correction.
In writing, signed, dated.
Order,
this has to go.
Yes.
And subject to correction.
But then if the chief wildlife warden is there, then it will be the state government.
My Lord.
Is it the central government office?
Yes, may I?
Central government.
My Lord, they have said a different procedure, which I do not find, my Lord, because the option is either managing authority or the authorized officer. They have said authorized officer is the state government officer, who is the respondent number 8. Who is the managing authority? I do not know. Yes, because that is the option given, either or.
আচ্ছা তাহলে কি বললাম বলুন তো?
ম্যানেজমেন্ট অথরিটি
না এটা হবে না। ওই লাইনটাই পুরো কেটে দিন।
4 or 8.
In view of the above, the competent authority is directed to communicate the petitioner the reason for rejection of his application,
Cancellation order.
so that the petitioner may proceed with the same for redressal of his grievances. Stop. Steps shall be taken in the matter at the earliest, but positively within a period of 2 weeks. Communication only.
My Lord.
Your ladyship,
forward their petition to me so that I can straight away hand it over to the
Yes.
concerned
You must be having a copy.
Your Lordship, I'm not party in all the. I have not been briefed.
In this matter, we
In
are
this matter, I am appearing, my lord. In this matter, I am appearing.
whoever the council is will forward it.
My lord, my lord, my lord.
Acha. Within a fortnight from the date of communication of this order. Stop paragraph. Be it recorded that the copy of the writ petition has been served upon all the authorities and the respondents are represented by the respective councils. Stop. The copy of the writ petition may be forwarded by the learned councils representing the respondents to the respective departments for taking prompt necessary action in the matter.
My lord.
Your Ladyship, may I indicate only one thing? Your Ladyship has rejected reasons for cancellation to be given, but
Yes.
if the order is not with me, order as contemplated.
Reasons
tonight,
means the reasoned order.
order.
Reasoned order.
My lord.
Otherwise, I apprehended they might only.
Reasoned order.
If
যেখানে
indicated
reasons
reasoned
বলে
order,
It has to be.
reasoned order করে দিন।
It
Yes.
has to.
And
And
the time of two more
2
things.
weeks.
The time to file appeal is supposed to run from the order of.
Obviously. From
Obviously,
the
that has to be
order
60
that will be
days.
communicated from the date of the reasoned order.
Reasoned order, my lord.
The cart cannot be put before the horse. It has not been
My lord.
communicated.
And in
And the date of appeal will be fixed.
In the meantime, no coercive steps may be
That
taken
may
because
continue.
we have faced this.
All right.
Some of us have faced this.
They take away the birds or what do you all
Yes,
do?
they
The birds are
prosecute
taken
us.
away.
Yes.
But even not confiscation of the birds.
All right.
Section judgment in personal because several of them would be coming there.
Each and every matter separate orders will be passed because see Mr. Mazumdar has got a different case. The other council has a different case. Acha. কি বললাম ওটা as non-furnishing of the as non-registration of the birds leads to penal consequences. Accordingly, the respondents are restrained from taking any coercive steps against the subject birds for a fortnight after communication of the reasoned order.
As also the owners.
60 days is the time.
And also the
for
owners.
appeal. 60 days
Fortnight's time I've been giving you. 60 days the court is not granting you time.
Birds as well as the owners.
As well as the owners.
Owners are not taken away.
Yes,
Owners are prosecuted, my lord. They are prosecuted.
They are taken
into custody. Yes.
Released on bail.
Acha, tale birds and their owners. Birds and their owners. Very well. Take this back.
I'm extremely grateful, my lord.
Preempt করে ফেলবে না? Preempt হয়ে যাবে। Appeal করার একটা preemption হয়।
Reasoned order. Communicate the petition and the reasoned order. The reasoned order.
But only one humble submission.
ঠিক আছে
Even in the order of rejection or
Yes.
But we tried to find out if there is an appellate authority through an RTA application. The reply is there is no appellate authority designated.
There is no appellate authority?
Your Lordship, I shall also communicate.
We will.
Yes.
Will.
Add up করে দিন তো।
In the event that we fail to get a protective order within 15 days, apropos the 60 days time period to prefer an appeal, we will be in a hanging situation.
Shall also reflect.
Yes. The reasoned order shall clearly specify the appellate authority so that in the event the petitioner is aggrieved, an appeal can be preferred within the stipulated time period.
রেজিস্ট্রেশন 30 দিন দরকার 3 দিনের মাথায় করে দেয়।
97 এর ফাইলটা দিয়েছেন 97
appeal না করে তুমি ধরে রেখে
দরকার 60 days আমাকে অ্যালাউ করুন 60 days তো সেকেন্ড অ্যালাউ করুন
97
97.
97,
same
my lord,
order
no
which
lordship.
has
No, lordship had
different order.
some direction was there by your
Yes,
lordship, my lord. May I
yes.
respectfully invite your lordship to, my lord, the order dated 22nd January
Yes,
2025.
please give
The
any
specific instruction was paragraph 5, a specific instruction shall be obtained as to whether any formal order of rejection was at all passed, and if passed, whether the same was communicated to the petitioner, whether the grounds for rejection. My lord, I have some materials given to me by the officers. My lord, here, lordship kindly recollect. May I respectfully hand over, my lord, this copy of the instruction, my lord. Before
Did
going,
you hand it over on the last occasion? No.
no, did not, my lord. That's why lordship was pleased to direct me to
All
get
right,
this
all right.
specific, my lord.
Hmm.
Before that, my lord, may I respectfully invite your lordship, my lord, to, my lord, to have a quick recap of the issue, my lord. Page 159, my lord, of the writ petition, my lord.
Yes.
159, my lord, says, my lord, there were as many as, my lord, 18 applications. My lord, then, my lord, the order, my lord, that intimation of rejection comes from page 160
onwards
to, my lord, 16, my lord, 7.
Yes.
So, out of 18, my lord, we have rejected 8. So, my lord, regarding 8, my lord, kindly have a look, my lord, now the instruction part. We have annexed, my lord, these are the uploaded documents. Starting from, my lord, page 4, my lord, may I respectfully invite your lordship, my lord, to page 4 onwards of the instruction, my lord. Pagination at the bottom, lordship.
At the top,
And
right.
this clause 14. Source document.
Same thing was placed in the last matter
Lordship.
also. But
So
is
now
this known
these
to
are
the
the uploaded,
petitioner?
lordship. These are the uploaded. They do not have the access.
Yes.
They don't have the access.
Right.
So since my lordship's direction was to come with specific instructions, so I have come up with. And
It's
put it
all
on
right.
record.
Instruction is there, but the earlier order possibly will cover this also.
So the intimation rejected.
It is the intimation. Grounds not known.
Same
Same
order
order.
can cover this.
May I specify? The
It is be kept on record.
Certainly.
MOEF conducts the entire procedure. Digital signature is put on all documents by the authorities. That may be specified by way of a digital signature.
No,
Because I have
because
specific
that is for you to explain in a further proceeding if they say. But here your law says, notification says signed. It is not digitally signed. So I am not accepting. Same order will go down in this. শুধু একটা line add up one line the instruction dated such and such forwarded by such and such be written with records. Yes. What are the other numbers?
Mr. Mujumdar is here.
Since Miss Pandey is appearing.
67 first.
67 days.
87 to 93 was.
87 to 93 আছে।
97.
তাহলে কেউ নেই।
সার্ভিস আছে। Affidavit service
Out of turn নিচ্ছে।
Can similar order be passed
Yes,
in
ma'am.
your matters also?
Yes, madam.
Intimate your other side and let this order be uploaded first. Go through it. If minor modification is required, then it can be done. Friday it will appear. Give the numbers.
My lord, I have given the list.
You've
List
given
of
the list?
my lord, the petitions are appearing in the list.
All right. Friday it will
Friday,
appear.
top of the list,
But
madam.
let this order be uploaded first.
If it can appear as to be mentioned or any other head. Very.
Not to be mentioned.
Some precedents, my lord, because we are also apprehending, my lord.
I'll see that it can be done. Urgent motion er opor dike diye deben to. Top of the urgent motion list.
Grateful to you.
Yes.
Can we take your last order?
Provision for considering hardship.
My lord.
Show.
Lord,
Before that, मतलब একটু দেখিয়ে দিন। Well, there was in the first policy also, there were certain provisions for hardship. That pertains to relaxations of certain provisions of the export-import policy itself. But kindly take first, the 2009 to 15 policy, paragraph 2.5.
Page. Oh, you have the book. All right.
Got the entire
Yes.
left-hand page, paragraph 2.5.
Yes.
Plus
Exemption from policy.
exemption from policy or some relaxations, then this hardship, you need to show the hardship.
May pass order.
There was also
on
grievance
grounds of
redressal
state
mechanism.
Hardship and adverse impact on trade.
That is
Yes.
that.
This is the trade policy of 2009-2014.
Yes, 9 to 14.
Yours is under the same policy.
Same policy.
All right. So,
This was regarding exemption or relaxations of this policy term.
but not to the incentive.
Not to. Now, in our case, I said, that certain circular was issued, restricting the technical textiles to 33 items. It came into effect on 21st October 2011, and it was given to prior to that to all technical textiles. But what they said, they gave a retrospective effect of that particular circular. But that was our case. Kindly take first, this is focus product scheme. Kindly take page 24 first. 3.1.5.2.
Yes.
Exports of notified products as in Appendix 37D of HPV to all countries shall be entitled for duty credit scrip equivalent to 2% of FOB value exports for exports made from 27th of August 2009. Now, these a particular item, that was, it was technical textile. Now, kindly take, I have the amended, page 32. এখানে অনেক পড়া আছে, আমি ওখান থেকেও দেখাবো।
Yes.
Get it technical textile woven practice of synthetic filaments, serial number 183, at page 32. This includes this amendment, the amendment made on, these are modifications made on 21st of October 2011 for export with effect from 1/4/2011. That was the retrospective effect given. The original technique in this book, let's kindly wants this book. Originally, it was only technical textile. Kindly takes this is let's get it from serial number 33 of right hand page.
Serial number 33.
33 right hand page. Only technical textile. Now this by this circular dated 21st October 2011, it was limited to only 33 items. So prior to 21st 11, all exports of technical textile, they were entitled to this 2% benefit. Now that was restricted to 33 items, but it was given a retrospective effect from April 2011. Our case was that the exports which had taken place between April 2011 to 20th October 2011, those are entitled for this benefit because these were the accrued benefit. And that was withdrawn. Now kindly take the circular of 21st October. That will also will get it page 29.
Period is 21st October 2011 and the
It was given effect from 1st April 2011.
Yes.
Now, this Honorable Court, page 39, on the same issue, held that it cannot be.
Yes.
Honorable Court relied on a Supreme Court decision. They kindly take page 41. For those reasons, that's already marked.
Yes, yes.
For those reasons, these writ applications are allowed to the extent that the respondent authorities are restrained by an order of injunction from denying any duty benefit to the writ petitioners earned by virtue of export of goods understood by the parties as technical textile before 21st October 2011. The notices issued by the department to deny duty benefit to the writ petitioners and making a demand for reversal of the duty benefit are without any effect for export before 20. But I make it clear that the respondent authority will be free to proceed in accordance with the said policy circular with regard to the exports on and from 21st October 2011. Well, our claim was pertaining to the period prior to 21st October 2011. But after 1st April 2011, for this limited period of 6
Between
months.
1st April till 21st October 2011.
Yes.
Yes, please.
Now, I had cited two decisions on the last occasion. One is 2006-13 SCC, page 542.
Yes.
Paragraph
48.
48. Copy has been.
Yes, it's here.
Now, another judgment I had cited, 2016 2 SCC, paragraph 113. Thus, you have taken note. Both says that the policy can be amended, but it cannot be given a retrospective effect to withdraw the benefit accrued. Now, so far as my claim is, my lord, I will be citing another decision. Report 2003 volume 2 SCC page 641.
Yes.
But here new policy came into force. The Supreme Court has said the benefit accrued under the old policy that is bound to be allowed. Paragraph 11 onwards. Principle remains same. Paragraph 11, the short point to be decided in these appeals is as to whether the respondents were admittedly entitled to grant of additional license under the old policy stand debarred from claiming the said additional license because of the new import-export policy which came into force 1/4/1990, and further the applicability of the circular 11 of 1993 dated and the effect thereof. Now, this was the issue. To kindly take paragraph 14. What was the policy that was narrated after subsequent paragraph 14? Coming to the point raised, it is to be noticed that paragraph 215 of the old policy is clear and provides that eligibility to the additional license was to be determined on the basis of the admissible exports made in the preceding licensing year. Paragraph 222 of the new policy, which has been extracted above, provides that where the applicants from export house, trading house for additional licenses for any of the preceding license have not been disposed of by the end of the licenses will be issued as per the relevant policy provisions prevailing during the period to which the additional licenses relate, meaning thereby that if an application for additional license for any preceding license year is pending, which in this case shall be deemed to be pending as the controversy is still alive, being adjudicated, then the license has to be issued as per relevant policy provisions prevailing during the period to which the additional license relates. I'll also rely on these because they will be citing this hardship point. In the old policy, there was a grievance redressal mechanism. Our applications were pending. That was transferred, that was virtually heard by this policy relaxation committee and rejected. Now, may I just continue? The grant of additional license in paragraph 222 has been made subject to the conditions that the permissibility of the items allowed for import against such licenses will be governed by the relevant provisions of the import policy in force at the time of their actual import, meaning thereby that the items which can be imported would be relatable to the import policy in force, the new policy. Transitional arrangements stated in paragraph 222 make it abundantly clear that the applications from export house, trading house, which have not been finally disposed of by the end of licensing year would be entitled to the issuance of the additional license as per relevant policy provisions prevailing during the period to which the additional license is related. The entitlement of the export house, trading house to get the additional license has not been taken away. The only conditions to which additional license has been subjected is the permissible items allowable for import against such additional would be governed by the provisions of the import policy in force at the time of their actual import. Contentions raised on
Don't read any further. If it goes on for a long time, then it won't be adjourned motion, it will go to the hearing bundle.
No, I'll say, my lord, the Supreme Court has specifically.
Yes, I have followed your submission.
Yes. My lord, now
Yes.
the rejections, your lordship has already taken note. The first rejections is at page 63. Case number 94, my lord, we had specifically took the point of the judgment of this honorable court in the Eastern Traders. The lordship has taken note. The committee went through the statements, the decisions. My lord, the committee went through the statements made by the firm, noted that the applicant has not submitted cogent reason justification in support of genuine hardship faced by them. Accordingly, this committee decides to reject the request of the firm. But if your lordship permit me, I'd say, my lord, if anything is illegal, my lord, no question of, my lord, establishing genuine hardship.
Very well, let me hear.
My lord, so far as my learned senior friend's contention is concerned, my lord, two things are required to be considered. First of all, my lord, lordship may kindly consider, my lord, the focus product scheme, as my learned senior friend was.
Yes.
My lord, clause 3.152, it specifically, my lord, says export of notified products. This, my lord, duty credit script, my lord, of 2% FOB value, my lord, they are entitled to get, which they are claiming. Now, my lord, they have, my lord, made representations. My lord, at least 3 representations have been made in the year 2012. And then, my lord, subsequently, my lord, in order to create a new cause of action, my lord, they have made representation in the year 2017, if I am not wrong. Before a, my lord, different, my lord, authority altogether. My lord, now, my lord, they have made representation before the policy, my lord, redressal committee. My lord, the scope of, my lord, policy redressal committee is very narrow. If your lordship kindly comes to, my lord, the same, my lord, policy, my lord, which your lordship is looking at. My lord, I'll just request your lordship, my lord, to kindly come to 2.5.
With 2.5.
My lord, may I hand up,
book,
my lord, may I hand up, my lord, a copy of this, my lord, policy?
Is a hearing required?
Yes,
Because
it requires
opposition and nothing has been filed.
Nothing has been filed.
The court was initially looking into the thing as to, as has been submitted, the hardship ground. If you cannot substantiate, then I'll send it back to them.
No, my lord, the hardship ground, I can substantiate.
There is
That
a ground.
Yes, my lord,
And there are reasons.
in order to get, my lord, the benefit of, my lord, the hardship ground,
Yes.
my lord, in order to get exemption, they have to show hardship. This hardship, my lord, is never, my lord, pleaded in their representation. Your lordship kindly looks at their representation for once.
The contention is that hardship cannot be a ground for rejection. Not pointing out the hardship cannot be a ground for rejection.
Yes, it can be a ground for rejection, my lord. Lordship kindly see for
In that
that.
case, you file your opposition.
2.5.
Please come.
My lord, may I use our opposition, my lord?
Yes, please.
Lordship.
The decision of the Decision of the
2006.
which committee is this?
Policy Redressal Committee, Lord.
No, no,
Policy
policy
re-
relaxation committee.
Relaxation Committee, I'm
The
sorry.
policy
And there are the
relaxation
reviewing
committee.
authority also.
Rejecting the request of the petitioner for grant of benefit under the FOP. What is it?
No, the focus product scheme.
FPS scheme. In its meeting held on 29th of November 2021, annexed at page 63 of the writ petition is impugned herein.
But another order is, my lord, the review order, page 67, 66, my lord. It is 28th December 2022. 28th of December 2022, page 66, bottom,
66.
and continues to 67. Decision is they just reiterate the earlier decision.
The decision of the review committee affirming the order passed by the Agekar committee is also impugned within bracket page 67 of the writ petition. Learned advocate representing the Union of India.
Lordship.
Seeks to file affidavit in the matter. Stop. Let affidavit in opposition be prepared and circulated by 4 weeks.
Lordship.
Reply, if any, within a fortnight thereafter. A liberty to mention the matter for hearing. After completion of affidavits, this book has to go.
My lord, one humble submission, my lord, the maintainability of writ petition, my lord, I am challenging. Because, my lord, they are, my lord.
An issue has been raised with regard to the maintainability
Lord, I can
of the
accept
writ
their, my
petition.
lord, maintainability issue should be, my lord, should have been urged first, my lord.
The same is left open to be decided at the time of final hearing.
Grateful.
Yes.
Well, let them, my lord, only on record, my lord, they need to just justify the reasons, my lord.
There is a provision for appeal.
3 weeks, no provisions for appeal.
Yes.
There is no provisions
will
for
not
appeal.
say no.
Next matter, please.
Section 15 is clear.
Of Foreign Trade Development Regulations Act. তুই পাগল হয়ে গেছিস নাকি? I have got the Foreign Trade Development Regulations Act. This maintainability issue, my lord, should be, my lord, arch first.
In the policy itself, there is a provision.
There is no provision.
Yes, 9. Who is there?
Right. I am for the applicant.
Yes.
For the matter regarding the non-payment of dues, analogous matter, my lord, which I earlier ordered on 16th of.
Matter, my lord. Can lordship taken up this? There are a bunch of matters, my lord,
Yes,
wherein my lord, learned advocate general will address before his lordship. So, my lord, he says, my lord, just now, my lord, that if lordship taken up this matter, bunch of matters tomorrow, my lord.
Oh, the election payment of election.
That's what, my lord, he said, my lord, he will come. He will come and address. From 11 onwards, I am appearing. Possibly there is a difference. The difference is in 11 onwards are the matters where there are 2 orders of your lordships.
No, in his matter, 11 onwards, yes.
Now, 11 onwards, initial order was pay, give a report within what time? And second, they came up with a, like we are holding a committee and committee will take about 8 months like that. Then lordship specific paragraph 8 order was that
within which it can be paid.
Within what time? Now, so therefore they cannot simply seek a time. They have to say.
No, they only.
This advocate general will appear. That's
he
what
will address.
Yes.
What is the address? I do not know. What
he says only make a prayer of not today. But all I'm praying is 1 day accommodation only. If the 11 or those where I am appearing, if that is there, so
same prayer in 11 also.
Yes, my lord. He will address all the
9 onward, 9 to 8.
9 onwards, my lord. There are matters, my lord, analogous matters. Only 9.
There is a direction.
No, 20.
There is a direction.
He will take care of all this. Let him come.
My
only thing.
62, my lord. 9 to 62, I think.
But the only thing possibly lordship would be required to put 2 categories. One category, no order by your lordships. Other category, there are 2 orders. Thereafter, everything would be same.
I get it, but the thing will be the same.
Right,
yes.
Right.
Whether it is 1 category or 2 category, whether they will make payment.
Well, I am ready to what my learned advocate general wants to say.
It's fair enough.
Let
Yes.
him come and say,
Yes,
otherwise the
that's
court
what- that's
doesn't
what.
know.
Kindly fix the time, my lord. Otherwise, tomorrow time, my lord. Fix the time.
You fix up your own time. The court will run according to the list that is
Because
there.
Advocate General is not available.
He'll be available.
Has to be made available.
He'll be available. Don't worry about the AG.
Yes.
Yes, 9.
9, 10 also, my lord.
All right, now on the prayer made by the learned advocate representing the respondents. টানা হলে পরে বোঝা যাবে না যে এজির জন্য টাইম নিয়েছে। On the prayer made by the learned advocate representing the state respondents. The matter stands adjourned.
Tomorrow, my lord.
কালকে আবার সময় হবে কখন?
My lord, may I give the numbers?
না কালকে তো হবে না। Tomorrow is Thursday. Applications taken
Oh,
up.
lordship, the applications thing.
Day after tomorrow.
Lordship.
Friday. 31 আগে একটা একটা করে হোক। Please give the appearances separately. 10
10, my lord, a similar matter.
respondent. Please put in your appearance. Will it be your same submission that the AG will address?
Yes.
11.
On 11, I appear for the petition.
Yes. Respondent. Nobody is there. Petitioner appearance কিন্তু সেম হয়ে যাবে 11 থেকে।
I think, my lord, 9 to 62. Almost.
No.
Please wait. You do not take the responsibility of the others.
Okay.
11, nobody is there for the state? None for the state. In that case, I'll pass orders. If nobody is there for the state, then order will be passed.
11, lordship, advocate will be here.
Mr. Basu Mullik's appearance লিখে নেবেন।
Yes, my lord.
On the prayer of Mr. Basu Mullik.
Lordship. আছে এই তো মুশকিল। Find it out.
12.
But 12, this is other matter.
12 is a different matter. Yes. Take it 12.
Madam, may I?
For the
76 to I am for the petition. 93 election regarding
1 minute, I'll go on one by one.
আরে না রে বাবা।
12, item 12 is
But 12 is a different matter completely.
the others I can take care. I am aware of what your submission is. What is the submission? Just let me know that it falls in the same bundle, same order will be passed. 12, who's there for the petitioner?
I am for the petition.
Please come. এটা কোনটা দিলেন? এটা 12 দিলেন?
Lordship, in this matter, on the
What is it about?
it is about the defreezing of the bank account, Lordship, keeping amount lien. Your Lordship was directed on the last occasion to serve upon the police station of the Hare Street. Perhaps the bank has appeared, Lordship. This is my affidavit of service.
You are for the bank? What is the amount that is found in fraudulent transaction? Given copy?
Lordship, we have not yet.
Number 11 and the audit machine. My lord, as per my instruction, my
Why did you not serve this copy earlier? He could have gone through it. What is the amount?
my lord, page number 34, my lord.
Yes.
Total amount in their bank account is 92,36,672. My lord,
Page 34.
page 34, my lord.
Yes, the amount. Unit 10,000, 10,000 lakh. 92 lakh.
92 lakh. My lord,
Yes.
may I say the facts in a cut short, my lord?
No, I just want to know how much is the amount involved in the fraudulent transaction.
That has not been communicated from the from any investigating agency, my lord. That all the papers I have annexed.
You just cannot close down his entire account.
No, my lord. But it is true that that an investigating and agency.
Let the investigation continue.
For account. And the judgment they have placed earlier occasion, the Madras High Court judgment, my lord, in that the judgment was passed on 10th of September, and further progress has been made on the same case, my lord. on that matter, before the Madras High Court, Bank Authority mentioned the matter, and further order has been passed, and the same order was recalled, my lord. My lord, first order 18th of October, my lord. It's fix the date on 28th. Council third para, my lord. Third page, third para. Third the lined council. Third page, third para.
Yes, yes.
Council on either side and perused the material available on record. It is seen that the writ petition was already disposed on 10th of September 2024, and as of stated above, and now it is brought to the notice of this court that many complaints as against the petitioner are pending before the police. Therefore, the details regarding the transaction and
That order has been recalled.
my lord.
No, but then you tell me the amount involved in the fraudulent transaction.
Unless and until the preliminary investigation has not been complete.
Page 17 and 18 in the writ petition that has been intimated by the bank. Even we have, there is a communication.
Preliminary investigation has not been complete, my lord. So
17 and
17 and 18 in the writ petition.
Page number.
Regarding my lord, page
These
number
are all different accounts. No, it's the
regarding
same
my lord,
account
page
number.
18, may I submit one thing, lordship?
Amount is unit and if you add up these amount, how much does it come to? Page 18, certain amount mentioned. If you add up, how does it come?
May I just submit one thing, lordship? In page 18, lordship, if lordship may kindly take the serial number 9.
Yes.
It has been stated that the amount of 1,20,000 has been frozen.
Yes.
And then if your lordship may kindly take the serial number 4.
4.
Where it has been stated that 1,20,000 has been unfreezed. So it is done at their whims, and we even do not know what is lie against us. And if your lordship may come to page number 16 of my application, lordship, there is a specific.
This is your request to defreeze it.
My lord, further direction has been made. Well, recently, my lord, on 21st January this month. Today, I received copy, my lord. Again, one investigation agency communicated to us to freeze the account, my lord. So the amount is not specific, my lord. So unless and until the specific amount is ascertained, we cannot defreeze the whole account.
So there are several complaints lodged against this. Not one.
The difficulty is that
my lord, kindly come once, page number 34 once, my lord.
34 of the
my opposition, my lord.
Opposition, yes.
My lord, last 3 transactions, kindly check, my lord, last 3 transactions, my lord. Only 3 complaints, we comply, 3 order from various courts, my lord.
34.
No,
As per court order.
Yes, my lord.
11 lakh, 32 lakh, 64 lakh.
That has been debited from the petitioner's account to complainant's account as per court's order, my lord. 3 courts order. I have 3 courts order as well.
From the petitioner's account to the complainant's account. These were
any
debited.
intimation to us, lordship.
These were directed to be debited.
Yes. By the court, my lord.
We have no knowledge about those proceedings, lordship.
Court's order, you all do not have knowledge. It was in March and August 2024. What does your farm do? What is the business about?
Lordship.
It is Mary Farmhouse. It's a farmhouse over there.
No, my lord. More or less 2 crore amount of 2 crore is credited to their account, and all the transactions are vague, my lord. And investigation agencies are suspicious that that may be amounts to money laundering case and all.
Please come.
Your lordship may kindly take paragraph 1 of my application. We deal with the agricultural items.
Educational items?
Agricultural items.
Agricultural items. If it were in opposition, on behalf of the respondent number 3, is taken on record.
May I file a reply to the affidavit in opposition,
What
Lordship?
is the use?
Lordship, may I get only one chance, Lordship, to file a reply? A short date may be fixed. Within a week, we will file, Lordship.
In the opposition, the bank has annexed the copy of the passbook of the petitioner, wherefrom it appears that the closing balance in the petitioner's account is rupees 92,52,672.70. Stop. The last 3 transactions from the said account were made by the petitioner. Now, were made from the account of the petitioner to the account of the complainant in terms of the order passed by the court. Stop paragraph. According to the bank, the investigation in respect of the complaints lodged against the petitioner's bank account is continuing, and the amount involved in fraudulent transaction is yet to be ascertained. Stop paragraph. It has been submitted that there are several complaints lodged against the bank account of the petitioner, and there is every probability that the bank account of the petitioner is used for money laundering purpose. Stop paragraph. The complaint against the bank account are from different states of the country and not under a single police station. Stop paragraph. Next. In view of the above, there is no scope for passing any order to defreeze the bank account of the petitioner.
Lordship, may I come with a
At
reply?
this stage. Stop paragraph. It will be open for the petitioner to avail the remedy in accordance with law before the competent forum if so advised. The writ petition stands disposed. Service is taken on record.
Dismiss kore diyeche. My lord, I'm sorry, my lord, I was engaged in court number 35.
No, why sorry? It's good that you are engaged.
Lord, I was rushing, Lord, from that building.
Take your rest.
Lord, your
Take your
lordship,
time.
they have filed in opposition, Lord. Your lordship has called for a report from the bank. Your lordship has dismissed, my lord, my report.
No, dismissed. I have disposed it off by holding that at this stage, no order can be passed for defreezing. At this stage, you can approach the proper forum in accordance with
May I
law.
address your lordship, Lord, on the point of at this stage?
No.
Because of the reason, Lord.
Do not address because there are several complaints from several states. Not one.
That is what I was
Had it
about.
been one,
That is what I was about to explain, your lordship, Lord. Your lordship would kindly hear me for 2 seconds. Lord, nowadays, what has happened, Lord, this kind of cases, Lord, there's a portal. Now, if anyone lodges a complaint, Lord, in that portal, the portal, Lord, registers the case. Now, Lord, thereafter, whatever account is involved, whatever accounts, Lord, in all these accounts, Lord, are being frozen. Lord, why I am saying this, Lord, it is the money.
Here we are concerned with only one account.
Why I'm
bank account of the petitioner.
Lord, yes.
Complaint not from one person. Complaint from various persons.
Lord, yes. Yes. Why I'm saying, because there are 2-3 accounts. Lord, yes, there,
Places as well, different states.
Lord, that is what I was trying to impress your lordship, Lord. Supposedly A, B, and C, there are 3 accounts. I am dealing with C account. Now the C account is linked with X and Y. This X and Y is involved. Since because of, Lord, I do not have any direct transaction with X and Y. Since Lord X and Y is having Lord some crisis, because I was also dealing with B, A and B. Since Lord I'm attached to Lord C, that's the reason Lord every complaint is coming to me. I've been nabbed to that litigations.
This court is regularly passing orders for defreezing bank accounts where the amount is specified.
Lord, here also Lord subject
No, it's
lordship
not
and sanction
specified.
Lord.
It is not specified. The case is different.
That is,
had it been the same, I would have passed order for defreezing.
Lord, there
This matter
my
I cannot
grievance
help.
is Lord just merely.
I cannot help. Sorry. Yes, 13. Same order as 11. Appearance of the state.
Look, I appear for this state.
Please give your appearance.
13 to
It is fixed up day after tomorrow. Learned AG will address. This is the submission. Same as 11.
14 to same. 14 appearance.
14. Appearance. 15.
Same, your lordship.
Appearance given. 16.
My lord, I am appearing on behalf of the finance department. My lord, in this matter, there is certain development, my lord, and the money has already been sanctioned from the finance department.
Oh, that is so good. Let me see.
Yesterday,
At least in one matter. देखी कागजটা দিন আগে. And when is it to be credited in the account of the petitioner?
My lord, yesterday evening, my lord, they have got the file, my lord, and from the home department.
No, but then it does not say so. It says we may release. We may release as per the recommendation. But release order is not there. No, sorry. This will not serve the purpose.
I am appearing only on behalf of the finance department, not on.
Sir, you are appearing for the government.
Yes.
There cannot be anybody above you. Right? So it is the same order goes down and put this in the file. Same order. 17. Please put in your appearance. 18 is also same?
Yes.
Yes.
Same.
19 is same? 20 is same?
Same.
21?
Same.
22? Yes, please. 23? Put in your slip. 24?
Same.
State's appearance has gone down. 24? State's appearance? In case it is not there, record Mr. Basu Malik's name.
Your Lordship, I am there for 24, Your Lordship.
20, you're there? Then it's all right. 25? 25?
Same, Your Lordship.
26?
Same, Your Lordship.
27?
70. But 27, I am not appearing.
27.
27 is a different matter. Oh, it must be an electricity matter. WBSCDCL.
May I have your Lordship kind clearance? 40, only 40. After that, 43.
Yes, well, 43, but I am appearing.
60,
Same.
60. Between,
Are different.
Yes.
I am not appearing.
You may not appear. You are also not appearing.
No, in 43, I am appearing.
Yes.
40, 1 minute. 27, none appears for the parties. Adjourn for the day. 28. 28 is a different matter. Same order. Adjourned. 29. Same, sure. Who is for the state? Is it for the first time? File degi. হ্যাঁ সেমই হবে 10 নম্বরও তাই ছিল first day very well same who is appearing for the state 29 record Mr. Basu Malik on the prayer of Mr. Vishwabroto Basu Malik 30 is also same 30 for the state Mr. Basu Malik 31 somebody was appearing in person none for the petitioner adjourn for the day 32
32 I am there. Mr. Billogal Bhattacharya was arguing this matter.
different matter
Yes, it's different matter.
None for the petitioner adjourn for the day 33
33, I am for the petitioner, Your Lordship.
Yes, please.
Your Lordship, I am led by Mr. Anandu Mitra, senior advocate.
So,
Your Lordship, can short pass over, Your Lordship.
no, madam, it cannot be done.
So, Your Lordship, tomorrow.
On the prayer of the learned advocate representing the petitioner, the matter stands adjourned for the day. Who is your other side?
Your Lordship, state and impleaded party is point number 4, led by Mr. S.N. Mukherjee. Both the councils are not.
Intimate them.
Your Lordship, gratefully.
Please put in your name.
Yes, Your Lordship.
34, same as the other matter. 35. 35 is a different matter. The 35 is a different matter. None for the petitioner. Adjourn for the day. 36, same as 11. 37, same as 11. 38, same as 11. State's appearance should come in. 39.
I'm for college authority.
College authority. Petitioner.
My lord, I have to file a report, my lord.
Give.
My lord.
Did you serve copy?
No, my lord.
Why not?
The report to my lord, before the my lord, my lord.
Report dekhi.
My lord, college authority had affirmed affidavit of compliance, my lord. My lord, report is at page 7. My lord, last annex. This is relating to a RTI application. As per my lord's order.
Submission was, if I can correctly remember, that the breakup of marks was
My
not
lord,
there.
my lord, my lord.
So, including the breakup of marks of all the candidates in connection with the selection process in the official website, which is now available in the aforesaid website of the college at home recruitment. Very well, please come. এটা কোনটা হচ্ছে 39?
39, my lord.
An affidavit by the respondent numbers 4, 5, and 6 filed in court today be written with the records. Stuff let copy of the same be served on the learned advocate representing the petitioner. List the matter on 11th, 11 February.
Page.
40 is same as 11. 41. This is a different matter.
41 different.
Yes. Where is the petitioner? Petitioner was
27
here.
is also different matter. 27, my lord, we are for the respondents. We are present, my lord.
We have report, my lord.
27. Electricity matter, ma.
Yes.
I have report,
Different
my
matter.
lord.
Lordship,
I have received a report.
Petitioner.
Not state.
Petitioner.
We have of the state.
The petitioner is not here. I have adjourned it.
Adjourn for this. Very well.
And by passing an order.
By passing an order.
Yes.
Then, my lord, I have already given my name.
Late appearance.
Kindly, my
Put
lord.
in your appearance also.
Great, great, great.
41. You're for the state? None for the petitioner. Yes, I was looking for you. What is it?
Is the revision of rent, my lord, initially done to 19,000. Suddenly, my lord, they withdraw it and reduced it. That matter.
Oh.
Kindly recollect.
Already I have submitted report, my lord.
Yes.
Copy handed over to your learned friend.
Yes. Latest.
My lord, in 1991, my lord, premises was let out to 1,577 square feet. But periodically, the rent was revised. Initially 10%, my lord, then after every 5 years. After 5 years, now there is a policy of state government that came into force on 29th of April 2013. It says, my lord, it should be revised afresh. But kindly straightway come to the policy, my lord, page 27.
Yes.
Clause November 1994.
29th April 2013. Considering the rapid hike of the rate of rent in the market, the rent shall be enhanced up to 20% at the present rate.
Where are you reading?
Clause 2 last, bottom of the page, 27.
Page 27 of the report.
No, of the
Read petition. 1 minute.
Report, in the report also that was annexed, my lord.
Page 27, yes.
Yes, bottom.
Considering the rapid
Considering
hike.
the rapid hike rent market, the rent like enhanced 20% of the after every 3 years instead of existing 20% after enhancement of rent shall be made automatically. Now the maximum per increase of the last 3 lines, the enhancement of rent may be made 3 times consecutive, and then the rent shall be assessed afresh after 9 years. The same hiring department continue occupy the same premises. Here the premises was occupied since 1991. Now, initially, then the department also forwarded the case, page 29, citing this policy for determination of rent afresh. Kindly take page 29 once, this was CDPO forwarded. Now, this was done, page 31. It was 4,000 and something, then it was revised, page 31. The rent of rupees 19,450, has you also got it? With effect from 1st December 2020. But this was not paid. Now, what they did, kindly take page 32. After 2 years, this was of 10th December 2020, nearly after 2.5 years. Suddenly, they revised it 6,309.
So it has come down, reduced.
Reduced. No reasons, nothing. No, it was given from 1st August 2020 only. It was also from 1st August 2000, with effect from 1st December 2020. Now it was given from 1st August 2020 because the last revision was till 1st August 2020. Now they filed a report.
1 minute. Page 31. It is dated 10th of December 2020,
Yes.
where the rent was assessed at 19,000
450
and odd, with effect from 1st December 2020.
20 with effect from.
Yes.
Now this was no withdrawal, not referred to even. This was reduced by additional district magistrate. This was done by the special land acquisition collector, the first revision, who was the competent authority. Now the additional district magistrate reduced it to 6,309 with effect from 1st August 2020.
Prior to page 31.
Yes, last rent was revised, was murdered on 1st August 2017.
Page number?
That is at page 26. You also will get it.
26.
This is the last revision.
Page 26 with effect from 1st August
2017. That is
So
why
18,
after
19,
3 years,
20.
that 1st August from 2020.
Right.
Now that was
20.
done. No hearing, nothing.
4,206.
Yes.
Right.
Yes.
Now, did 9 years, was 9 years over?
long back.
9 years over long back.
To
So it has to
1991.
be afresh.
It has to be afresh, and afresh it was done also. This 19,000 was properly assessed. They have annexed the assessment chart or the calculation sheet. Kindly take this calculation sheet. Page 28
It
of
has
the
come
report.
down. No, very well, I have followed. You are aggrieved by page 32.
Yes.
What is the report?
Yes, kindly take page, first page. They said, kindly again come back to the circular of page 27.
Yes.
Now kindly take the last paragraph 8.
Yes.
Now, in case of assessing the rent for the premises hired 30 years back, we generally follow the geo number such and such dated 23rd November 1994. In these cases, we may assess it as fresh one. In this present case, it was fresh one. Now, kindly take this 1994 geo that they have annexed in the report.
But why will we go to 1994? There is
They
no
cannot.
reason.
Now, what they did, even if I can show that from 1990, they did not follow even this 1994 circular. That I want to show. How, on what basis they have done it, not disclosed in the report. There is no reasons for these reductions. They have annexed the reasons for this 19,000, but no reasons for this 6,000. Kindly first take page 28. Page 28 of the report.
Yes.
The entire the fresh assessment, initial
19,000 is here.
Yes. Area was 1,500 and something, it was reduced to 1,200 and something. After fresh measurement and
How
survey.
can area be reduced?
I don't know, but it was reduced after
Is it
fresh.
shrinking? Is the area shrinking?
I don't know, but whatever I gather from this report, that area was reduced. Now it was reduced. In any event, this was assessed at 19,449. Now this 94 circular is in partial modification of a circular of 1993. You also will get it from the first paragraph, page 27. It has been observed that the recent years that rents of the premises which were originally hired 30 years back earlier is much lower than the market rate of the similar accommodation in the locality, even on revised usual manner laid down in the government order of 11th August 1999. After careful examination, it has now been decided that the revision of rents for hired accommodation which were originally hired 30 years back or earlier, rent should be assessed in terms of the circular quoted above. The revised rent in such a should be freshly assessed rent, subject to condition that the assessed rent should under no circumstances be more than 150% of the existing rent fixed. The first is 11th August 1993. This was in partial modifications of this 11th August 1993. Now, this 11th August 1993 parent circular has been superseded by 2013 circular.
Yes.
Now, how they can now fall back, and even if 150% comes to more than 10,000. Now, they assessed it 6,000. Now, they have annexed. There's no reasons. Unilateral. Kindly take the same document, page 32.
Why has it been reduced? The ground for reduction.
No reason in the affidavit, paragraph 11, whatever they said.
This is not an affidavit. This is just a report.
Report. Paragraph 11, kindly take.
Paragraph 11.
Paragraph 7 first.
7.
The bold, the geo stated.
Yes.
Geo stated in revising rent for hired accommodation which were originally hired 30 years back or earlier should be assessed in terms of circular 1993. The revised rent in such cases should be freshly assessed and subject to condition that the assessment should be 150%. That was the then paragraph 11. This geo of 1993 is no longer subsisting, so partial modifications also goes. Paragraph 11. Now, I'll also cite, my lord, another document, my lord. The same reason that it should not have been more than 150%, the premises was had, so 1993 and the partial modifications of the 94 should be followed. This was, they have given no reasons for how they have come to this assessment, nothing has been disclosed. Now kindly, but now this 2013 has been further superseded. Now, on another document, my lord, philosophy, kindly see. My lord, page 37 of the report. Just once, my lord. Page 37 of the report.
The reasoning has been mentioned. You say it has not been done. Reasoning is mentioned. It is paragraph 8 of the 2013 circular. Now the court has to interpret it.
That paragraph 8, but the basis of coming to 6,300, that has not been disclosed. Nothing.
No, that is 150%.
But that doesn't, my last revision was 4,000 something. If it is 150%, it comes to more than 10,000. 4,000, I'm giving the details, my lord. It is
page 34 of the report.
4,206.
34.
That was 2017.
Yes, it will be around 10,000.
More than 10,000. I have made the calculations. My lord, it comes to, I'm just giving the calculation. It comes to around 10,515.
True. It cannot be more than.
Cannot be. But one another thing, my lord, kindly take page 37 of the report.
37. Yes.
Now kindly take page. This is the fresh, my lord, the notification superseding event 2013. This 29th April 2013 has been superseded by 16 June 2022.
Yes.
Now kindly take page 39. Clause 6. Cases where fixation or revision rate inspector provision already settled and accepted in a manner mentioned should not be reopened and redetermination for such in respect of said premises during the period of validity of such fixation or revision of rent. Now kindly in my case, kindly take my lord page 31. This was done on 10th of December 2020 prior to this my lord, June 22 circular. Page 31. You also will get the date. This 10th December 2020. The assessment was prior to that. Now this revision, impugned revision was done in 9th March 2023 after coming into force of this circular. They could not have altered it. 9th March, next page 32. Can you see the date?
No, but then this was in 20 and the one you are referring to is in 22.
22. Now my revision assessment was done in 2020.
So 22 was not in existence at that point.
At that time. But 2023 when they are making, they are really again revising it to page 32. This is 2023, 9th March 2023. They could not have done it. 9th March 2023. That is after coming into force of 2022 circular.
Yes.
It's prohibited by clause 6.
Right.
And
Yes.
they themselves disclose the assessment, how these calculations have been made.
My lord, page 34, my lord.
Of
report, my lord. Kindly see.
See, right now, the only circular that is prevailing is 16th of June 2022. You have made the revision in 2023. How could you do it? This is the only question. Nothing more.
My lord, I want to try, my lord, for clarification from the higher authority. Respondent number 5.
All clarification is here. You engage a junior member who can assist you. All right. The documents that are before the court are enough for arriving at a decision. You please engage a junior counsel who will assist you in this matter. How soon can this be done?
My lord, I want to file affidavit in office.
No. The report is here, no further affidavit. How soon can you take the assistance of somebody? Either you with somebody or with you somebody. How soon? I'll post it next week or week thereafter. Next week, we do not have much working days. 12th of February. Heard detailed submissions made on behalf of both the parties. Stuff. The petitioner is aggrieved by the revision of rent mid-term. Revision of rent mid-term made on 9th March 2023. Stop. The rent of the petitioner, the rent payable to the petitioner has been reduced to rupees 6,309 only per month with effect from 1st August 2020 from the rent of rupees 19,450 as assessed by the Special Land Acquisition Officer, North 24 Parganas, Barasat, on 10th December 2020. Stop paragraph. According to the petitioner, the same is contrary to the guidelines published by the Department of Land and Land Reforms and Refugee Relief and Rehabilitation Rehabilitation, dated 16th of June 2022. Stop paragraph. Clause 6 of the said circular clearly mentions that cases where fixation and or revision of rent in respect of premises already settled and accepted by the government should not be reopened or redetermined during the validity period of such fixation/revision. Stop. Learned counsel representing the state respondents is directed to come prepared. List on 12th of February. Jana Babu, put this at the top of the urgent motion bundle. At the top.
$42, my lord, I am appearing for the petitioner. In earlier occasion, your lordship directed me to serve the copy of the application as well as to file a report by the State Bank of India.
State Bank of India.
Yes. My lord, I served.
Somebody is appearing. Name is appearing over here.
My lord, that is
SBI card.
Postin Nair. I served copy of the writ application. My lord, I served to the State Bank of India. He did not receive. For that reason, your lordship directed me to serve copy of the writ application and obtain instruction and to file a report before your lordship. Because here the petitioner is a retired employee by way of credit card, which he did not receive at all. The amount from his pension
Are
account.
you aware of his phone number?
My lord, phone number আছে না? Chamber is my lord, I know that is 10 old post office phone number.
Ensure his presence. The matter will be there in the list. Just call him.
My lord, remain in its own
Yes, same position. 43.
My lord, 43 is same as item number 11. Mr.
11,
Dubey
yes.
said-
Straight. Yes, give your appearance. Same as 11. 44.
I'm for the petition in item number 44.
Yes.
But here the bank has already given their proposal. And I was instructed to take I was directed to take the written instruction from my client regarding this matter. Lordship, prima facie, this matter was related to the payment of the outstanding amount to the bank. And Lordship was pleased to direct them to come up with the proposal. Proposal came. Now, Lordship, what has happened? We have, these are the points I've taken. I made an affidavit. Lordship, I'm giving them a copy. There are certain objections regarding the calculations as well as their claims. Particularly, Lordship, considering one of the documents, it suggests that the information was furnished by the competent authority of the Office of the District Magistrate, No.24 Parganas. There was a question specifically asked regarding the issuance of the notice under Section 14. The reply is that as per the available official records, the department, Lordship, the affidavit, copy of the affidavit, this is the copy. Lordship, this is the affidavit copy. Lordship, kindly come to.
What is the proposal of the bank first say?
Bank's proposal, Lordship, was total 14 lakh.
52,238 is due.
Yes. And now bank says that it is 14 lakh and 14 lakh 44,872. This is the kindly come to paragraph number 5.
Yes. Now what
They
is
want
your
to settle it in total 14 lakhs.
All right.
Now in 14 lakhs, out of these 14 lakhs, what has happened that if the problem is, Lordship, regarding, kindly come to paragraph number 5. It says that 14 lakhs and in this amount I already paid the EMI, which amount is 5 lakh 80,400 with the interest according to the statement on account. Rest amount is 8 lakh 19,600. So this is one discrepancy which was detected. Number 2, Lordship, kindly come to page number 15. I made an application under RTI Act before the concerned court, before the concerned
Why
office
going
of the
to all
district
these
magistrate.
things right now? 14 lakh is there in front of you. Are you agreeable? Are you not
Lordship, this
agreeable?
is not possible. 14 lakhs, it's not possible for me
Yes.
to deposit within 31st of January. That is
All
the
right.
position, Lordship.
Hmm.
So if I'm given given some time extended, I may pay some. That is, Lordship.
See, the court is not accepting the money. It is between
I
you and the
understand.
bank.
So there is a problem regarding this. I cannot pay it by
That means
31st
the
January.
proposal of the bank you are not accepting. You
Yes.
approach the tribunal for relief. Please come. The bank has filed an affidavit disclosing the proposal for settlement. Stop. According to the bank, the debt of the petitioners shall stand fully and finally settled for an amount of rupees 14 lakh to be paid as one-time installment within 31st January 2025. Stop. Paragraph, the petitioner will not be able to pay the aforesaid due within the time limit as granted. Stub paragraph. Accordingly, it appears that the proposal of the bank cannot be accepted by the petitioner. Stub paragraph. As the proceeding arises out of the SARFAESI Act, comma, it will be open for the petitioner to approach the competent forum for remedy. Petition
One more observation, Lordship will kindly observe the application, whichever, if filed by the petitioner, would be decided by the district
If
commissioner.
filed, which application?
The section 17 application, if the
Let
petitioner
him
wants to
file.
challenge. Well, the one apprehension is that the district magistrate's order is of 10th July 2024. The
Yes.
limitation for preferring an appeal from that order has already expired.
Right.
So, if they file an application, that would be subject to the period of limitation as regards maintainability of that application.
The authority will decide.
Yes,
whether
madam. The authority
why
will
would
decide.
this court
Madam, kindly observes that. Madam, only that thing. Madam, otherwise, madam, they will interpret as saying that this court has granted liberty to
No.
approach, and that's why the limitation has
It
not
is
begun.
open to approach the competent forum in accordance with law if so advised.
Yes, madam. In accordance with law. My lord.
If the limitation is there, it is there.
Yes, madam. But previously, I faced this. Madam, that is why I have.
No,
The only thing is that I wanted the thing to be in a written form, so let it be retained with the record, Lordship.
What thing?
The written version of the petitioner.
What is the use?
Otherwise,
No use at all.
grateful.
Grateful.
একটু ডাকুন কতগুলো সিমিলার ম্যাটার বলছিল কোনগুলো?
For the petitioner.
It's already past 4:30. It is already past 4:30. Your other side is also not here. I'm just looking for the similar matters where order was
Matter in
passed.
respect of that, Malat.
11.
76 to 85 is my matter, and also 93.
Since they are not taken up, let it remain in the list. We'll see when it is taken up. Best way